have all the judging panelists here. So let me ask the judging panelists to turn off their, I'll do the swearing in and then we'll turn off cameras and mics. Okay, so here are some reminders as to some of the procedures in this particular version of our trial. First of all, are there any conflicts that any judging panelist wants to identify? Hearing none, we'll move on from that. You understand that this is being recorded, and I hear no objections to that from anybody. Okay, hearing none, we'll proceed with that. Let me remind the teams that there are no recesses unless the judge has an emergency. Now, if there is an emergency, do identify yourself and let me know. But otherwise, we will go straight through. Next is the compliance with time requirements. Remember, that's an obligation that both prosecution and defense have, and I assume they are going to honor that. So now let us have introductions from the prosecution identifying names of counsel and witnesses. Please, prosecution.
Good morning, Your Honor, members of the jury. My name is Katie Dolan, and today I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Professor Blake Van Owen, and giving the closing argument on behalf of the prosecution.
Good afternoon. My name is Mallory Hobson. Today, I will be giving the opening statement, conducting the direct examination of Kyle Cusack, and the cross-examination of Avery Becker.
Good morning, Your Honor. My name is Remy Peck, and today I will be giving the direct examination of Alex Fuentes and the cross-examination of Taylor Perkins. And may our witnesses introduce themselves?
Excuse me, counsel, repeat that last.
And may our witnesses introduce themselves?
Oh, please.
Thank you.
Witnesses?
Good morning, Your Honor, members of the jury, opposing counsel. My name is Stuart Terry, and I am Detective Jordan Markowitz.
Thank you.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Claire Van Kempen, and I'm Kyle Cusack.
Good morning, Your Honor. My name is Emmy Munn, and I am Alex Fuentes.
Thank you. All right. Defense counsel.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Peter Briggs. I'll be the third attorney on behalf of the defense, delivering the direct examination of Avery Becker, the cross-examination of Kyle Cusack, and the opening statement.
Your Honor, opposing counsel, and members of the jury, my name is Zoe Mans-Jackson. I'll be the first attorney on behalf of the defense. I'll be providing the direct examination of Blake Van Owen and the cross-examination of Alex Fuentes.
Your Honor, opposing counsel, members of the jury, my name is Jessica Bustillos. I will be the second attorney today, and I will be providing the direct examination of Taylor Perkins, the cross-examination of Detective Jordan Markowitz, as well as providing the closing argument. Our witnesses will now introduce themselves.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Olivia Dalfolo Daly. I am Professor Blake Van Owen, your first witness.
Your Honor, opposing counsel, and members of the jury. My name is Eleanor Briggs, and I am Taylor Perkins, your second witness.
Your Honor, opposing counsel, and members of the jury. My name is Jaylee Hepner. I am Avery Becker, your third witness.
Okay. Let me ask is there any panelist that, any jury member panelists that needs clarification on names? Okay, hearing none. We can move on to swearing everybody in. So we will do this in 3 parts. First part, let us have team members raise your right hands, please. I see hands going up. To the members of the teams, do you promise that the presentation you will give, it will be faithfully and truthfully conform to the rules of this mock trial competition?
Yes,
Yes, Your Honor.
Yes, Your Honor.
Okay, may the record reflect that all have answered affirmatively. Witnesses, do you promise that the testimony you will give will faithfully and truthfully, in fact, I see all the witnesses' hands up. Okay, that the testimony you will give will faithfully and truthfully conform to your statements, that you'll not add material facts, or which the facts are not contained in the case problem, and that you'll follow the rules and the procedures of this competition.
Yes, Your Honor.
Yes, Your Honor.
Okay, and we are not going to ask you two participants to do any swearing in, but let me ask the scoring panelists, please raise your right hands. And do you promise to adjudicate the mock trial competition objectively as possible in accordance with the facts, the rules of this competition?
Yes, Your Honor.
Do I hear that from all the panelists? Yeah, I hear one voice. Let's have an affirmative again.
Yes.
Yes. Thank you. Thank you. Okay, now we can ask the panelists to turn off their cameras and microphones, and we are ready to proceed. Is prosecution ready to call its first witness?
Your Honor, may we address some preliminary matters before we begin?
You may.
Okay, so the parties reached an agreement on a list of stipulated facts. Would you like a copy of that list, or would you like us to read off the stipulations?
No, I believe I have a copy, so that is fine. Any word from the defense on that? Hearing none?
No, Your Honor. We would just ask that those consider themselves published to the jury.
All right. We'll deem that, and we won't. We will let the jury take those into the deliberation room. We will not consume the jury's time right now. Next, preliminary matters, prosecution.
We ask your permission for all admitted exhibits from both the prosecution and the defense to be published to the jury.
Okay, here, defense.
That is permissible to the defense.
So those exhibits have been pre-marked, am I right?
They have, yes, Your Honor.
And the extent of the numbers, the pre-marking numbers are exhibits 1 through what?
9, let's see, 22.
Okay, so they are deemed admitted and they shall be published to the jury. Next.
We also ask that the court assume the witnesses have the exhibits in front of them, but while laying a foundation for an exhibit, we will state that we are showing the witness the exhibit, but we will not screen share exhibits until they are admitted.
Now, didn't we just have an agreement that they are admitted?
Yes, but we will not screen share until they are admitted.
You're going to have to unconfuse me. If they are admitted, can't they be screen shared immediately?
Yes, we just ask that they are not screen shared before they are admitted.
All right, we're going a little bit around in circles, but that's all right. Next.
And normally in a trial setting, we would stand for all objections. However, we understand that in this Zoom setting, the attorney shall remain seated, but otherwise we request to stand during opening statement, closing argument, and direct and cross-examinations.
Any objection from defense?
No objection, Your Honor.
Then you may do so.
And lastly, we just reserve any time that we have left on closing argument for rebuttal.
All right, so that's fine.
Thank you, Your Honor.
And is that a request also by defense?
No, Your Honor. I don't believe defense has the right to reserve time for rebuttal.
That would be appropriate. Okay, any other preliminary matters?
I have some, Your Honor.
All right, counsel, proceed.
I would first like the record to reflect that Rule 4.6 of the competition requires that the prosecution attorney delivering the opening statement is the one that ought to provide these stipulations, and that the prosecution attorney that did provide the stipulations is not the one providing the opening statement.
Does that make any difference other than the technical non-adherence to a rule?
No, Your Honor.
Okay. And then if it's posed as an objection, it's overruled. Next.
Your Honor, the defense would make a motion in limine pursuant to Rule 5.3.3 of the competition, excluding any evidence of Detective Markowitz commenting on the defendant's attorney canceling an interview with the detective, as this is the grounds being that this is an inappropriate comment on the defendant's right to remain silent.
Does prosecution wish to be heard on that?
No, Your Honor.
Okay, then references to contact with defense attorney are deemed inadmissible.
Your Honor, the defense is prepared for trial.
And is prosecution ready to proceed with calling your
Yes,
first
Your
witness?
Honor. We are
Or-
ready to present opening statements.
Okay, you wish to make an opening statement. Okay, then that's fine. Please go ahead, Ms. Dallin.
Your Honor, may I proceed?
So Ms. Hobson, you are doing the opening. Okay, please proceed.
Her heart is nearly thumping out of her chest. Her breaths become faster and faster. Her head is filled with rage and hunger for revenge. She tries the front door, locked. She ducks around the side of the house and into the backyard. She tries the back door. It slides open with ease. She slips inside the house, crossing the line from trespass to burglary. She assumed her coach would be at work. She was wrong. Mackenzie Brackman surprised her. They physically fought, knocking over plates, furniture, scuffing up the floor, until she finally got a hold of the murder weapon, a kitchen knife, and stabbed Mackenzie Brackman. Whether it was a spur-of-the-moment decision or not, she had done it. She had killed her mock trial coach. As Coach Brackman was left lying in a pool of his own blood, the defendant Avery Becker realized she had just committed murder and how her plan for payback had gone terribly wrong. The evidence in this case will prove exactly what I've just told you. Maybe Avery didn't cross that threshold with intent to kill, but once she stepped through that doorway intending to harm Coach Brackman's home, whatever followed next would be her own fault. Jury Instruction 7 states the law allows prosecutors to charge felons with murder for any death that occurs during the commission of a felony. So, when the defendant broke into her coach's home, what was a felony of second-degree burglary transformed into the felony murder she is charged with today. This is a case of an arrogant young woman, the star of the mock trial team, who was bent on payback for the humiliation she felt Coach Brackman had dealt her. Prior to the day of Mackenzie Brackman's death, the pair were constantly on thin ice. Avery resented Brackman for treating her just like any normal mock trial student instead of the superstar she was. After one particularly heated quarrel in which Coach Brackman called Avery out in front of everyone for a continual lack of preparedness, Avery decided she'd had enough and would get even for the embarrassment he caused her. So she vandalized his prized white Porsche, writing Worst Attorney Award across the hood in permanent marker. When Coach Brackman discovered this, he screamed at Avery that she was off the team for good. Fuming with rage and embarrassment, Avery decided to get the best payback she could ever imagine, to trash her coach's house. But as the people will prove beyond a reasonable doubt, Avery's plan for payback went terribly wrong. What started as a reckless act of retaliation ended with Mackenzie Brackman's death. Today, you will hear from Detective Jordan Markowitz, a seasoned police department investigator who will show us the call data records which tell us that Avery's phone was within the area of Coach Brackman's house at the time of the murder. These records will also tell us that Avery's best friend, Taylor Perkins, was desperately trying to get a hold of her throughout the day of the murder, but her repeated texts and calls went unanswered. Kyle Kuzak, an expert crime scene reconstructor, will testify how Mackenzie Brackman was murdered and the details of the struggle between the two over the murder weapon. Lastly, Avery's friend and fellow teammate, Alex Fuentes, will testify about the text messages she exchanged with Avery. In those texts, Avery openly admits planning to go to Coach Brackman's home to trash it. The defense will implausibly allege that Alex stole Avery's phone to set her up and fake those texts. They will also allege that Avery couldn't have committed this crime because she was with Taylor the whole day of March 6th, looking high and low for Avery's lost phone at the mall. But the only person who can testify to this is Taylor, the only alibi witness. Even if Avery didn't go into that home intending to harm her coach, Mackenzie Brackman is dead because of Avery Becker. Avery illegally entered Coach Brackman's home to teach him a lesson and was left with payback gone wrong.
Thank you, counsel. All right, at this time, does the prosecution, does the defense wish to present an opening, or does the defense wish to refrain until its case achieved?
We do have an opening statement, Your Honor.
And you wish to present it at this time?
Yes, Your Honor.
Okay, please proceed.
Your Honor, opposing counsel, and members of the jury, Avery wasn't there. She and Taylor were looking everywhere. On the morning of March 6th, Avery Becker awoke to the startling realization that her phone was missing. And so, for the entire day of March 6th, with Taylor Perkins, while someone else was killing Coach Brackman, Avery Becker was searching for her phone at the mall and at the Fry Shack. She went nowhere near Coach Brackman's house, and she did not kill Mackenzie Brackman. The burden of proof today lies on the shoulders of the prosecution. They must prove to you, beyond a reasonable doubt, that Avery Becker, on or about March 6th, broke into the residence of Mackenzie Brackman with the intent to cause criminal mischief, and thereto cause the death of her late coach. This burden exists because the law demands that juries assume every person innocent until proven guilty, beyond a reasonable doubt. However, at the close of the evidence today, you will see that this burden has not been met, that the evidence is insufficient. Because as the defense, while we have no legal burden of proof, we will have shown you the innocence in the courtroom by highlighting a lackluster police investigation, riddled with mistakes and assumptions. We will do this through the use of 6 witnesses, starting with the 3 presented by the prosecution. The prosecution will bring Detective Markowitz, who will insist that cell phone data places Avery's phone in Brackman's neighborhood, but will provide no meaningful evidence proving that phone was at Brackman's house, nor proving that that phone was on Avery's person, that they were in any way at the same location. The prosecution will also present Kyle Kuzak, who, as a crime scene reconstruction investigator, will tell you a story, but yet again will provide no meaningful evidence linking Avery to that story, to the crime scene. You will see that only through a series of assumptions is Avery accused. The defense will also present Alex Fuentes with a clear bias against Avery Becker, who has failed to provide their phone for the official police investigation. Because of this, any evidence supposedly derived from said phone should be taken with a heavy grain of salt. You will also get the opportunity to hear from 3 witnesses from the defense, starting with Blake Van Owen, an expertly qualified private investigator who will testify that there are many ways in which a digital image can be tampered with, underlining why evidence Alex claims to have gotten from his own phone ought to be questioned. Blake Van Owen will also highlight the many assumptions made by Kyle Kuzak in her official conclusions and the many shortcomings of the official investigation conducted by Detective Markowitz. For example, Blake Van Owen will introduce you to an alternate suspect named Blair Rollins, who had strong motive, and members of the jury, I urge you to listen carefully during the direct examination of Detective Markowitz for any investigation into this Rollins. As the defense, we will also present you with Taylor Perkins, who will corroborate Avery's alibi. Taylor will explain how she was with Avery during the time of the murder, how they were at the mall, and how Taylor was calling Avery's phone in order to locate it, and that those calls went unanswered. This testimony will cement in your minds Avery's innocence before we even get to our 3rd witness, the defendant herself. When Avery Becker takes the stand, she will describe in detail her activities the day of and time of the murder. She will explain how she lost her phone, how she was searching for it at the mall, and how she didn't even know where Coach Brackman lived. She will also describe the true sentiments between her and her coach, dashing any motive cast by the prosecution. Members of the jury, the prosecution will use the creativity of Kyle Kuzak to cover a lackluster police investigation, riddled with mistakes and assumptions. But don't let this fool you into perceiving a coherent story. The defense witnesses, on the other hand, will present a unified, cohesive, sensible truth of the events on March 6th, centered around the simple fact of the corroborated alibi. While the prosecution will present an appeal to prejudice, the defense presents the truth. At the close of the evidence, my co-counsel Jessica will implore you to reach a verdict of not guilty because the burden placed upon the shoulders of the prosecution will have not been met. You will find the evidence implicating Avery Becker to be insufficient, nay, non-existent. We will implore you to find Avery Becker innocent because Avery was not there. She and Taylor were looking everywhere. Thank you, Your Honor.
Very good. Thank you, counsel. All right. Is the prosecution ready to call its first witness?
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz to the stand.
All right. Detective Markowitz, take the stand. You have been sworn, so you may proceed.
Could you please state your name for the record?
Good afternoon. My name is Detective Jordan Markowitz.
Detective Markowitz, why are you here today?
I am here today to testify as an expert witness in the investigation of the murder of Mackenzie Brackman.
What do you do for a living?
I'm a homicide detective with the Denver Police Department.
How long have you been working for the Denver Police Department?
I've been with the Denver Police Department for roughly 13 years, and I've been a detective for 7 of those years.
As a detective, do you have any specialized training?
Yes. I have a cell phone technology and a forensic data recovery certification from the American Academy of Law Enforcement.
What did you learn during the training to receive the certification?
I learned how to obtain and interpret cell phone data, including cell tower records, and how to use forensic software to download information from a cell phone.
Do you use this information to form your expert opinions in court cases?
Yes, I have downloaded the contents of hundreds of cell phones. I have also obtained and interpreted cell tower data in over 50 cases.
Your Honor, at this time, I move for the admission of Detective Markowitz as an expert in the fields of cell phone technology, forensic data recovery, and police investigation.
Cell phone technology, forensic data recovery, and what's the last category?
Police investigation, Your Honor.
Okay, defense, you want to be heard?
The defense has no, I'm sorry, Your Honor. The defense has no objection to this witness being entered as an expert, Your Honor.
In all 3 categories?
Yes, Your Honor.
Okay, proceed.
As the lead detective, what were your responsibilities in investigating this case?
On Friday, March 6, 2020, a passing motorist saw Mackenzie Brackman's body on the porch. Officers secured the crime scene, and then I responded around 2:20 p.m.
Let the record reflect that I'm sharing a copy of Exhibit 1 with opposing counsel and with the witness. Detective Markowitz, do you recognize this photograph?
Yes, this is the victim, Mackenzie Brackman.
How do you know this was Mackenzie Brackman?
I saw Brackman's ID. Brackman was a criminal defense attorney. I investigated several homicides that Brackman later defended.
Is this a fair and accurate depiction of Brackman as you saw his body at the crime scene?
Yes.
Your Honor, at this time, I move for the admission of Exhibit 1.
Counsel, haven't all the exhibits been admitted, 1 through 22?
No, we asked for permission to admit those, yet we would like to go through the process of admitting them.
Okay, we're back to that. That's fine. Go ahead. The exhibit shall be admitted.
What did you observe when you first arrived at the scene of the crime?
I instantly saw Brackman's body, face down and in a pool of blood. I also saw a large knife on the floor just past Brackman's body. It was obvious that he had been stabbed.
Did you observe anything else on the front porch?
I noticed a Ring doorbell. Then I walked around the house and spotted 2 more cameras aimed at the gate to the backyard and the back door.
Once you went inside the house, what did you observe?
The residence was slightly in disarray, but I couldn't tell if this was the result of a struggle or just the normal state of the house.
Let the record reflect that I am sharing copies of Exhibits 7 through 9 with opposing counsel and with the witness.
I'll let the record reflect that as counsel, so you may ask permission of me to have the record reflect that, and then I will respond.
Yes,
So
sure.
that the record may so reflect.
Do you recognize these pictures?
Yes, these are pictures of the evidence from inside the house.
Do these pictures depict a fair and accurate representation of the evidence as it appeared at the time you saw them and they were photographed?
Yes.
Your Honor, at this time I move for the admission of Exhibits 7 through 9.
So admitted.
What do these pictures show?
I observed a partially open kitchen drawer that contained several knives, a knife block on the counter that had a large empty slot, and a broken plate.
What did you do next in your investigation?
I downloaded the information from Brackman's phone, obtained account data and passwords for his Ring account, and logged into his account.
What did you obtain from his Ring account?
I obtained the 4 videos that captured the intruder.
Let the record reflect that I am sharing copies of Exhibits 10 through 13 with opposing counsel. Your Honor, permission to show Exhibits 10 through 13 to the witness?
You have my permission.
Do you recognize these exhibits?
Yes, these are the videos that I obtained from Brackman's Ring account.
Are these videos a fair and accurate representation as you saw them on Brackman's Ring account?
Yes.
Your Honor, at this time I move for the admission of Exhibits 10 through 13.
So admitted without objection.
What do these videos specifically show?
The intruder was wearing what looked like a Halloween mask and gloves. The intruder first tried the front door, but it was locked. They then entered the backyard through the gate and entered the residence through the unlocked back door. Lastly, the intruder ran out of the front door.
What did you conclude from these videos?
It was a burglary gone wrong.
Did you consider who would have wanted to break into Brackman's house?
Well, since he was a criminal defense lawyer, it made sense to me that this could have been an angry ex-client. Even though this may have been an unlikely scenario, I need to weigh all options and not jump to conclusions. I always follow the evidence and go where it takes me.
So what evidence did you turn to at this point?
I looked at Brackman's phone and saw tremendous amounts of texts and emails related to something called mock trial.
How was Brackman related to mock trial?
I found out that Brackman was a high school mock trial coach for Colorado High School.
Did it seem likely that Brackman's mock trial activity had anything to do with his death?
No, it seemed highly unlikely. But, like I said, good police work requires you to follow the evidence presented.
Did you further investigate the mock trial team?
I reached out to Colorado High School in order to get contact information on the team.
Who did you get in contact with?
I first got in touch with a student named Alex Fuentes. Fuentes mentioned that another student, Avery Becker, who was kicked off of A team because she vandalized Brackman's car, texted Fuentes about how she was planning on trashing Brackman's house while he was at work. I then conducted a full interview with Fuentes and Fuentes' parents.
Could you identify the defendant, Avery Becker, in the courtroom?
Yes, Becker has brown hair and is wearing a gray blazer.
Did you obtain copies of the text messages?
Unfortunately, Fuentes forgot her phone at the interview, so I had Fuentes send me a photo of these text messages and I received them a day later.
Do the contents of the text messages corroborate what Fuentes talked about in her interview the day before?
They do.
And what do you conclude from the text messages?
Becker wanted payback on Brackman.
Did you investigate Becker further?
I obtained a search warrant to search Becker's cell phone, but apparently Becker had lost her phone a day before Brackman's death and no longer has it.
Did you get any other information on Becker's phone?
Yes, I got a court order to obtain cell tower records from March 6 using Becker's phone number. The account records confirmed that the phone number was associated with the account in Becker's name.
What did the cell tower records show?
According to the call detail records, a CDR, Taylor Perkins, another Colorado high school student, was sending several texts and calls to Becker's phone leading up to the murder.
Was Perkins able to get in touch with Becker?
No, Perkins was likely calling and texting Becker, but Becker wasn't answering.
Your Honor, let the record reflect that I am sharing a copy of Exhibit 16 with opposing counsel. Permission to show Exhibit 16 to the witness.
Hearing no objection, you have permission.
Do you recognize this diagram?
Yes, this diagram shows the location of the cell tower that Becker's phone communicated with in the time leading up to the homicide. It also shows the most likely route Becker was driving along.
Did you prepare this diagram?
Yes.
Was this diagram made using information and analysis you acquired from Becker's cell phone records?
Yes.
And is it your regular practice to obtain and interpret cell tower data, like in the diagram?
Yes.
Your Honor, at this time I move for the admission of Exhibit 16.
Hearing no objection, so admitted.
What does the diagram show?
It shows where Becker's phone was when she received a text or a call before the murder.
What texts and calls did you show on the diagram?
Becker received a text from Perkins through the cell tower that covers Becker's house. Perkins sent another text and the location showed Becker driving to Brackman's house. The last call and text came from the cell tower by Brackman's house. All activity on Becker's phone stopped roughly 3 minutes after the last text from Perkins.
What do you conclude happened to Becker's phone?
I conclude Becker's phone was turned off completely after the murder and likely destroyed and disposed of later.
Based on your expert opinion, what do you conclude the CDR data indicates?
Becker was at Brackman's house during the time of the murder.
Thank you. No further questions, Your Honor.
Do we have cross exam?
Yes, Your Honor.
All right, counsel, proceed.
Your Honor, before I begin, may the defense publish all of the exhibits 1, 7 through 13 and 16 to the jury, so it may be considered by the jury?
Any objection? Hearing none, the defense may.
Okay. Good afternoon, Detective Markowitz. I would now like to discuss March 6, 2020 with you. In March, you were assigned to investigate the death of Mackenzie Brackman.
Yes, I was.
You responded to the scene at 14:20 hours.
Yes.
You observed the victim at the front door of his residence.
Yes.
But didn't concern yourself with the body at first.
No.
You looked around the outside of the house.
I did.
And found a Ring doorbell.
Yes, I did. And then I walked around the house and spotted 2 more cameras.
The doorbell being a part of the house's security system.
Yes.
A system with various cameras.
Yes.
The killer was recorded by the cameras.
Yes.
You found lots of mock trial related items at his house.
His phone included several texts and emails related to mock trial.
But you highly doubted it was related to Brackman's murder.
I did, but as I said, I follow my evidence, and my evidence brought me to my conclusion that Avery Becker did kill Brackman.
But that's a yes, you highly doubted it was related.
I did, but I follow my evidence and don't go with my initial instinct.
If you could please direct your attention to Exhibit 10. Exhibit 10 is the front door camera, correct?
Yes, 1 second. Yes.
The murderer can be seen from there.
Yes.
The murderer is covered completely from head to toe.
Yes, the intruder was wearing a Halloween mask and gloves.
It is impossible to recognize the person simply by the video.
I did use the video as part of my evidence, but this was not my only evidence to recognize to come to my conclusion.
But with the video alone, it's impossible to recognize who's in the video.
With the video alone, but I collected other evidence that brought me to my conclusion.
I feel like there's some confusion. Just based off of the video, Detective Markowitz, is it possible to identify the intruder?
Not simply based off the video, but
I
Thank
used
you.
other evidence to come to my conclusion.
Every video of the camera shows the murderer wearing the same clothes as seen in Exhibit 10,
Yes.
but none of the cameras can identify the person.
No, the cameras alone can't, but with my
Thank
other
you.
evidence, I can.
I'll now ask about Mackenzie Brackman. He was a criminal defense lawyer,
Yes.
one who you described as being a displeasure to work with.
I didn't enjoy being crossed by Brackman in court.
Mackenzie Brackman may have been disliked by some of his clients.
Yes.
Clients he defended as their lawyer.
Yes.
Some who were on trial for murder,
Yes.
and some with violent histories.
Yes.
I'll now talk about Alex Fuentes. The first student you interviewed was Alex Fuentes.
Correct.
You built the rest of your case based off of what Alex told you,
Fuentes did provide me with a good lead.
without looking for other possible leads first.
I followed the evidence presented and I came to my interview with Fuentes and then followed the lead Fuentes provided me with.
But you didn't look at other possible ones first.
I didn't need to.
Alex told you about the text between her and another student.
Yes,
So you asked Alex to come to headquarters for a full interview,
I did.
based on the text between Alex and the other student.
Yes.
Texts that were on Alex's phone.
Yes.
Alex knew that you were interviewing her.
Yes.
Alex knew that you were curious about the messages.
Yes.
Yet Alex failed to bring their phone to the interview.
Unfortunately, Fuentes got a little nervous before the interview, and unfortunately, Fuentes forgot her phone.
And this was weird considering Alex is a high schooler.
Yes, but interviews can be nerve-wracking.
But it was weird.
Yes, but they can be nerve-wracking.
Alex is the first teenager you've encountered who didn't have her phone on them.
Yes.
And this is even more concerning because Alex knew her phone was important.
I do. Fuentes unfortunately forgot their phone, but it wasn't on purpose.
You only ever got sent screenshots of the exchange.
I did ask Fuentes to send me photos of the screenshots.
You never saw Alex's phone.
I didn't, but the screenshots did corroborate what she talked about in the interview.
Not once during the entire investigation.
Did I see her interview? Her phone?
Yes.
Yeah, unfortunately, Fuentes did forget her phone.
Nothing was done to verify the screenshots were confirmed to be authentic.
I didn't need to.
You have no proof that the images weren't manipulated with.
It is my expert opinion that these images were not manipulated.
But you have no proof.
I don't have proof, but I've been a detective for 7 years
Thank
and
you.
I understand my training and my background.
I would now like to discuss the cell phone data recovery you pulled on Avery's phone.
Yeah.
There is no way of knowing who was in possession of Avery's cell phone on March 6th.
Becker claims that she lost her phone, but I do not believe this. And
Allow me to restate my question, Detective Markowitz. There's no way of knowing who was in possession of Avery's cell phone on March 6th.
No, but with my other
Thank you.
evidence, I came to the conclusion that Becker was in possession.
There were several calls made to Avery's phone.
Yes.
And some texts as well.
Yes.
All from Taylor.
Yes.
The calls were so short that they indicate there was no reply.
Yes, Perkins was likely calling and texting Becker, but Becker wasn't responding.
And the messages, allow me to question. The phone gave no reply.
Correct.
And the messages weren't returned either.
They were not.
If you could please direct your attention to Exhibit 16.
Yes.
It shows the towers that Avery's phone communicated with.
Yes.
Cell Tower 1227-3 covers Avery's house.
Yes.
It also covers Blair Rollins' house.
It does.
Objection, lack of foundation for who Blair Rollins is.
Counsel will be heard in response?
Oh, yes. Your Honor, this is an expert, and I'm asking her expert opinion on exhibits that have been published to the jury.
Well, let's focus in on the question you just asked, counsel. Want to repeat the question?
It also covers Blair Rollins' house.
It meaning?
The antenna, which is on Exhibit 16.
Okay, you are establishing that the antenna covers a certain location, correct?
Yes, Your Honor.
Let me hear prosecution as to why your witness's expertise would not go, that you proffered as cell phone tower expertise would not go to the question in terms of foundation? Prosecution?
There just has been no foundation laid as to who Blair Rollins is.
Ah, okay, I'll sustain it. Counsel for defense, why don't you lay that foundation as to who Blair Rollins is?
Okay, Your Honor. Detective Markowitz, if you look at Exhibit 16 as a whole, there are several places covered by Exhibit 16, correct?
By the cell towers, yes.
One of them being Avery Becker's home,
Yes.
one of them being Mackenzie Brackman's home,
Yes.
and another being a home of a Blair Rollins, as identified in Exhibit 16.
Yes.
No further questions, Your Honor.
Redirect. Is that
Yes, Your Honor, briefly. What did the evidence point to in this case?
Avery Becker was at Brackman's house during the time of the murder.
And did you consider other possibilities of who could have been at Brackman's house?
I followed the evidence presented and came to my conclusion that it was, in fact, Becker at Brackman's house.
Thank you. No further questions.
recross on that narrow area?
No recross, Your Honor.
Okay. Does the prosecution have any other witnesses?
Yes, Your Honor, we call Kyle Kuzak to the stand.
All right, Kyle Kuzak, you've been sworn, so you may proceed, counsel.
May you please state your name for the court?
My name is Kyle Kuzak.
Ms. Kuzak, why are you here today?
I'm a crime scene reconstructor, and I'm here to discuss the murder of attorney Mackenzie Brackman.
Can you please tell us about your career?
Yes, I'm a Colorado Bureau of Investigation certified crime scene reconstructor investigator, also known as a CSR, and I'm currently employed with the Denver Police Department.
How long have you been a CSR?
Roughly 19 years.
What does your occupation require you to do?
I investigate complex crime scenes by conducting a comprehensive investigation and documentation of every case. And then along with my extensive, along with all of my experience, I also have investigated cases such as homicides, complex home invasions, armed robberies, and fatal accidents.
Can you explain the standard procedure you conduct?
Yeah, so with all of my investigations, I conduct a thorough and comprehensive investigation, and I document and organize all the evidence with the mindset of future reconstruction, and I do this through a 5-step process.
What are these 5 steps?
First, I go through the process of recognition and documentation, then I collect my evidence, then I evaluate said evidence, then for step 4, I formulate and test my hypothesis, and finally, I reconstruct the crime scene.
Your Honor, at this time, I tender Ms. Kyle Kuzak as an expert witness in crime scene reconstruction and investigation.
Any objection, counsel for the defense?
Permission for a brief voir dire, Your Honor.
So, does the prosecution have anything to say about a voir dire of the witness being proffered as an expert? Any objection to the voir dire?
No, Your Honor.
Okay, you may proceed, counsel.
Ms. Kuzak, you provide no curriculum vitae to the court.
No, I do not. I just tell everyone and be open about how many years of experience I have.
Of course, but you list no formal education in your testimony.
No, I do not. I really think that 19 years of experience really just tells everyone how qualified I am.
And moving on, you claim to use a 7-step method for event analysis. Can you tell the
Yes.
jury who invented this process?
Sorry, may you repeat that? I didn't hear the last part.
Can you tell the jury who invented this process?
Yes, I can.
Please
Well,
tell the jury.
Oh, yeah. So pretty much I kind of edit my own step process and follow what I think is best and how I've edited throughout the years.
I worry that I might have confused you. Can you tell the jury who invented the 7-step methodology that you use?
Oh, are you not referring to my Oh, sorry. Sorry, I understand that now.
It's also known as sequential unmasking.
Sorry, I didn't hear that.
Do you have an answer?
Yes, I do. Sorry. So I do this with the
It's all right. We can move on.
okay, sorry.
Your Honor, we have no objection, despite an apparent lack of knowledge of her own processes. This expert can testify under the crime scene reconstruction.
Okay, counsel for prosecution, you may proceed.
Thank you, Your Honor. Your Honor, let the record reflect I'm sharing with my opposing counsel and this witness what has been marked as Exhibit 17. Ms. Kuzak, can you tell me what this is?
Yes, this is a copy of my witness and evidence tracking sheet.
Did you prepare this document?
Yes, I did.
Was this document made near the time of the murder?
Yes, it was.
Was this document made using information and analysis you acquired in your reconstruction of the crime scene?
Yes.
Is it your regular practice to make a document like this one?
Yes, it is.
Your Honor, at this time, we move for the admission of Exhibit 17 into evidence.
Hearing no objection, it shall be admitted.
Thank you, Your Honor. Permission for my co-counsel. Oh, thank you. Can you elaborate on your witness tracking sheet and flow chart?
Yeah, so it summarizes the main points of information from the witnesses and suspects' testimony, and then I identify related segments and sort them into groups.
Did you visit the crime scene?
Yes, I did.
And after visiting the crime scene and reviewing the evidence, did you draw any expert conclusions?
I believe I did.
Objection, Your Honor. The defense would like to publish this exhibit to the jury before it is discussed, so the jury may take it into account.
Any objection, prosecution?
No, Your Honor.
All right, the jury is free to examine as the witness testifies. Go ahead, counsel.
Okay. Ms. Kuzak, would you like me to restate the question?
Yes, please.
After visiting the crime scene and reviewing the evidence, did you draw any expert conclusions?
I believe I did. So a person with the similar build and height as the defendant entered Mr. Brackman's porch and continued on to the south side of his residence, where they were caught on the home security cameras, and then they entered the house using the back door.
Where in the house did you investigate?
Everywhere, but I made most of my discoveries in the back of the house.
What were these discoveries?
So there were scuff marks on the kitchen floor near the back door, which suggests there was a sort of struggle between the victim and intruder. And then there was also a broken plate, which also suggests signs of a struggle.
Did you notice anything else while investigating throughout the house?
Yes, I did. The knife that the victim was stabbed with was different from all the other knives in the knife block.
Your Honor, let the record reflect I'm sharing with my opposing counsel and this witness what has been previously marked and admitted as Exhibits 7 and 8. Ms. Kuzak, are these the photos that helped you draw conclusions of the murder weapon?
Yes, they are.
What were these differences you previously mentioned?
Well, the knife the victim was stabbed with was from a Chicago cutlery chef set, whereas the knives in the block were from a J. Henkel set.
What expert conclusions did you draw from this?
I believe that the victim looked for a weapon to use in defense within his knife drawer, but eventually took the larger chef's knife to use from the knife block to use.
Ms. Kuzak, now I would like to talk to you about the autopsy report. Your Honor, let the record reflect I'm sharing with my opposing counsel and the witness what has been marked as Exhibit 19.
Record shall reflect.
Ms. Kuzak, can you tell us what this is?
Yes, this is the official autopsy report of Mackenzie Brackman.
Is this the same report you received while conducting your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 19 into evidence.
It shall be admitted, hearing no objection.
Your Honor, permission for my co-counsel to publish to the jury?
Permission granted.
In your expert opinion, what did you conclude from this report?
The victim was stabbed only once in the shoulder blade, and I do not believe that Mr. Brackman and the intruder were engaged for a long period of time before he was fatally stabbed.
What is the final expert conclusion you drew from this?
It seems that the victim approached the intruder and they fought over the knife, resulting in signs of a struggle like scuff marks and a broken plate.
What do you believe about the victim's awareness of the intruder at the time?
Well, for Mr. Brackman to be stabbed in the back, he would have needed to be surprised by the intruder, or rather unaware of the intruder. And given the circumstances, I do not believe this is possible.
Can you elaborate on these circumstances?
Sure. So with the door opening and the ring alerts, the victim was surely aware of the intruder. And the theory that the victim was stabbed at the kitchen table does not explain the scuff marks, the broken plate, the open knife drawer, or the empty slot in the knife block.
Finally, in your expert opinion, what do you believe happened in this case?
In my expert opinion, I think that this is an attempted home invasion that went bad and resulted in a fatal wound that led to the death of Mackenzie Brackman.
Thank you, Ms. Cusack. I have no further questions.
Cross?
Yes, Your Honor. Ms. Cusack, you make no mention of ever interacting with any tangible evidence in court today.
No, I do not, because I really just use the evidence I was provided with.
Which is photographs, audio, and video.
Yes, that is true.
All of these given to you by the police department.
Yes.
Your Honor, permission to screen share Exhibit 17.
Granted.
Hold on. Ms. Cusack, you created all aspects of this exhibit, correct?
Yes, I did.
I'd like to first direct the jury's attention to the first page. A piece of evidence was gathered from Avery Becker.
Yes.
You labeled this as evidence number 1140,
Yes.
and you don't record what evidence 1140 is.
No, I do not.
But you did incorporate it into this framework.
Yes, I did.
It influenced your conclusions.
Well, along with a ton of other evidence.
Of course, but this is part of the document that influenced your conclusions.
Part of it, just one small part.
But this part is not available to the jury today.
No.
And you claim to organize all evidence into this framework
Yes.
because the framework as a whole helps you come to your conclusion.
Yes, and I think it really helps me and everyone else who looks at it better understand the case.
Of course, but you do include potentially fallible evidence in your framework.
Yes.
Understandable. On this first page, you list 3 suspects.
Yes, I do.
You list Avery Becker.
Yes, she is suspect 1.
You list Blair Rollins.
Yes, I do.
You even list Fuentes as a suspect.
Yes, I do, because I had to be ready to investigate all possibilities.
So Fuentes was a suspect then?
Yes, but emphasis on was a suspect and is currently not.
Now I'd like to direct the jury's attention to the 3rd page. You created this flowchart.
Yes, I did.
In the first of 5 steps to efficient CSR work.
Yes.
Before evaluating the evidence.
Yes, I did. I just
In
wanted
fact,
to organize.
You based this document off of an interview with Detective Markowitz.
Yes, Detective Markowitz was very helpful.
And you indicate that the intent of the burglary was property damage.
Yes, I do believe this was a home invasion gone wrong.
But you indicate that the intent was property damage as opposed to theft.
Yes, I do believe the intent was property damage.
But at this stage, you don't indicate in your testimony what evidence led you to this conclusion.
No, I do not.
Only Detective Markowitz.
Yes, because I really thought that Detective Markowitz was qualified enough to speak about this.
Now I'd like to move on to some of the physical evidence. Permission to stop screen sharing, Your Honor.
Correct. Granted.
You saw photos of blood spatter.
Yes, I did, but sadly, these are corrupted images.
So they're not available to the jury.
No, they're not available, but I did see them.
But they're not even available to you anymore.
No, they're not. I just saw them, but then they were corrupted.
Now I'd like to move on to some of your conclusions. Is that all right?
Yes.
You had access to the ring videos we saw earlier in court, did you not?
Yes, I did.
The person in these videos is wearing a mask
Yes, along with gloves.
and a jacket.
Yes.
The perpetrator's fingerprints weren't found at the scene of the crime.
No, we couldn't do that due to gloves.
The perpetrator's DNA wasn't found at the scene of the crime.
No.
So you base your analysis of the identity of the intruder off of their build.
Well, build and height, and then that's not the only thing we use to identify the intruder.
But that's the only aspect of the video that you used.
Yes, that's the only aspect of the video.
I'd like to discuss some of your testimony about the knife. You believe that the murder weapon came from the victim's kitchen,
Yes, from the knife block.
even though there was a knife drawer open.
Yes, I believe that he looked for a knife in the drawer, but then eventually took a larger chef's knife to defend himself.
However, you did testify that this murder weapon does not look anything anywhere close to any of those knives in the knife block.
No, they're not the same.
And there's no mention of the police ever testing to see whether that knife fits in the block.
No, there's no mention of that.
Now I'd like to back up and take a look at the investigation as a whole. You say this seemed like a straightforward home invasion,
Yes.
but you weren't able to recreate all event segments.
No, I was not able to.
And your conclusion does not account for all of the evidence.
Well, however, I do include quite a lot of evidence.
So that's a yes. Your conclusion does not account for all of the evidence.
No.
For example, there was no blood spatter until the knife was pulled out.
Yes, that is true.
You say this evidence would have helped you locate where the stabbing occurred.
Yes, but from the autopsy report, we could see it was in his shoulder blade.
No, I mean in the house, where in the house the stabbing occurred.
I understand.
Finally, you reviewed Blake Van Owen's report,
Yes, I did, and I didn't agree with it.
but some of her conclusions lie outside of your level of expertise.
Yes, however, I am a crime scene reconstructor, and Van Owen isn't even a crime scene reconstructor.
No further questions, Your Honor.
Redirect of the witness.
Yes, Your Honor. Ms. Cusack, can you refresh us on what your occupation entails?
I'm a crime scene reconstructor, and I gather pieces of evidence that I'm provided with.
And could you tell us again how long you have been a CSR?
Roughly 2 decades or 19 years.
Thank you, Ms. Cusack. I have no further questions.
Recross.
No, Your Honor.
All right. Does prosecution have any other witnesses?
Yes, Your Honor. Prosecution would like to call Alex Fuentes to the stand.
All right, Alex Fuentes, you are sworn and you may proceed, counsel.
Could you please introduce yourself to the jury?
Absolutely. My name is Alex Fuentes, and I go to Colorado High School.
Are you a member of the mock trial team?
Yes, I am.
Who is on your team?
Avery Becker, along with Taylor Perkins.
And who's your coach?
Mackenzie Brackman.
Could you describe your experience with Mr. Brackman as your coach?
Yeah, I really liked having Brackman as a coach. He knew the legal system very well, and it was enjoyable.
What is your relationship with the defendant, Avery Becker?
Avery and I have been friends for a while. She actually convinced me to try out mock trial, but high school's pretty busy, so I really only see her at mock trial practice.
How are Avery's mock trial skills?
Impeccable, although sometimes Avery was...
Objection. Relevance.
Prosecution.
Your Honor, this goes to credibility and for Alex Fuentes.
May I respond?
Yes.
Your Honor, the defense counsel is asking Mr. Fuentes how Avery's mock trial skills were, and I fail to see how that goes to Avery's credibility.
Prosecution want to answer?
Your Honor, the answer that Ms. Fuentes is, the question is asking about Avery Becker's credibility and her skills on mock trial, which involves acting, and the witness is testifying to how she is and Avery's credibility.
All right, I'm going to sustain the objection. Proceed, counsel.
Ms. Fuentes, did you and Avery have any conflict?
No, I mean, maybe little things, but definitely not anything significant.
I mean, honestly, I was just jealous that she was so naturally incredible at mock trial. I mean, who wouldn't be?
And what did you observe the team's response was when Avery came to practice unprepared?
Well, I think that sometimes it caused a bit of anxiety just because we saw mock trial as a team effort. And so by Avery not preparing, she didn't really contribute to that, but we got over it.
Did you observe any conflict between Avery and Mr. Brackman?
Yes, often Avery and Brackman got into little feuds about going by the books versus improvising.
And was there a specific point when things were especially bad between Avery and Mr. Brackman?
Yes, this one practice when Avery was late yet again, sort of like the tip of the iceberg for Coach Brackman. And after that, Avery was demoted to B team. And then Taylor quit the team, and then Avery was put back on A team, and it was a whole mess.
Do any other instances of conflict between Avery and Mr. Brackman stand out to you?
Yes. After we went to regionals, where Avery did spectacularly, by the way, the practice afterwards, the tension was very high between the two of them.
What do you mean by tension?
Well, they got into a full-blown argument, and Avery got so upset she ended up vandalizing Brackman's car, which then caused her to be kicked off the team.
Did that affect you at all?
I mean, yeah, she was permanently kicked off the team. This time she was off for good, so to speak. And as excited as I was for the new position, good opportunity, the team had a better chance of winning when Avery was a part of it.
Did Avery make an effort to get back on the team this time?
Yes, she texted me.
So you and Avery texted back and forth that day?
Yes.
And what did you learn from the text messages?
Well, I basically learned about her plans of breaking into Brackman's house while he was gone, and I was astonished.
Your Honor, I'm permission to show opposing counsel and the witness a copy of what has previously been marked as Exhibit 14.
Granted.
Could you please identify Exhibit 14 for the court?
Yes, these are the text messages between Avery Becker and I.
Were these texts exchanged between you and Avery from your personal phone?
Yes, they were.
Are these the texts that you gave to Detective Markowitz?
Yes, they are.
Is this an accurate representation of the text between you and Avery?
Yes, 100%.
Your Honor, I move to admit Exhibit 14 into evidence.
Hearing no objection.
I do object, Your Honor.
Okay, admitted.
I have an objection under Rule 1003 on admissibility of duplicates.
Okay, so did you register an objection, counsel? It sounded like no objection.
Oh, I'm sorry, Your Honor. Yes, I do object.
Okay, you object to the text messages being admitted on what basis?
Rule 1003, admissibility of duplicates as a genuine question has been raised by Detective Markowitz to this exhibit's authenticity.
Okay, counsel for prosecution.
Your Honor, under Rule 901B1, Alex Fuentes is a witness who has direct knowledge of the item because Ms. Fuentes has testified as that she is the one who took the screenshots of the text messages.
I'm going to admit it. The messages are admitted.
Thank you. Ms. Fuentes, are these screenshots from your phone?
Yes, they are.
Is this your text exchange with the defendant, Avery Becker?
Yes, it is.
And what did the text say?
Well, Avery was basically trying to get back on the team. And that last entry at the bottom, that's what really blew me away. I mean, it's where she stated her plans of breaking into Brackman's. Look where we are now.
And why didn't you just show the detective your phone?
Well, I clumsily left my phone at home. I was in quite the rush to get down to the police station. So I even offered to go back and get my phone, but the detective insisted that screenshots were just fine.
Had anyone else seen these screenshots?
Yes, I believe some investigators saw them because I was starting to be accused of faking the text messages that I was sending to Avery, which is absolutely ridiculous. I would never do that to a good friend. And on top of that, I'm being accused of stealing Avery's phone and giving it to some kid named Blair.
What was your relationship with Blair Rollins?
I barely know Blair Rollins, and I know some are saying that I stole the phone and gave it to Blair, but I don't know them. And even more so, Blair's not on the mock trial team, so I don't know them from that either.
And are you still friends with the defendant, Avery Becker?
You know, it's sad because Avery and I used to be really good friends, but due to these circumstances, it has made it really difficult. But based on what she said to me and based on what she did to the car, she killed him.
Thank you, Ms. Fuentes. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Hello, Mr. Fuentes.
Hi.
In your statement, you say that throughout your time on the team, Mr. Brackman often wasn't happy with Avery for her lack of preparation.
Yes, they didn't agree on very many things.
You, however, prepared furiously for your mock trial competitions.
Yes, I was very devoted.
You claim in your statement that despite this difference in preparation, you and Avery were of similar skill level.
I like to think that.
And despite being similarly skilled, you agreed with Mr. Brackman's decision to demote Avery to B team the first time he did it.
In some ways, yes.
Is that a yes?
Yes.
You even went so far as to ask Mr. Brackman why he put up with Avery.
Yes.
And you asked that multiple times.
That's correct.
In your statement, you go so far as to claim that Avery won awards based off of looks alone.
And her natural improvisation, yes.
But that's a yes. You do say that about her looks.
Yes, I do say that about her looks.
I'd like to discuss your relationship with Miss Becker. You and Avery pushed each other often in mock trial.
Yeah.
So much so that in your statement, you say there was a rumor you and Avery were rivals.
Yeah, but I mean, that's absurd.
Let's talk about the text messages that were just brought up in direct examination. You should have a copy.
Yes, I do.
Regarding the first instance, you say Avery asked you for help getting back on the team.
I believe that is why she reached out, yes.
And you said yes.
Yeah.
And regarding the second instance, you told Avery that Mr. Brackman said no, she couldn't be let back on the team.
Yes, he was quite upset.
But you say in your statement there are two different text conversations.
I do believe there are two, yes.
And these text messages give no indication of two different timestamps.
No.
All right, let's move a little further down the timeline. Brackman wouldn't let Avery back on the team after the incident with the car.
No, he was very upset.
But personally, you believe that Avery should have been hit with criminal charges for that incident.
Yes, I mean, not just pertaining to Avery, whoever vandalizes someone's car definitely deserves punishment.
However, in your statement, despite that, you claim you and Avery were best friends.
Like I said, no matter my relationship with her, she did something bad and she deserved punishment.
That's a yes.
Yes.
Moving along, you can confirm that Avery was at the Fry Shack on March 5th.
Yes.
And a few weeks ago, someone you believe to be a private investigator came to speak with you.
Yes, that's correct.
But you refused to speak to her.
Yes.
Despite having information.
Mm-hmm.
You found out you were being accused of stealing Avery's phone.
Yes, like I said, absolutely ridiculous.
And giving it to Blair Rollins.
Even more ridiculous, yes.
Right, so you're claiming you'd never do that.
No, I would never steal someone's phone nor give it to somebody that I don't know.
Because you'd never put Mr. Brackman in danger.
No.
So you believe that giving the phone to Blair Rollins could put your coach in danger?
I suppose, yeah.
Is that a yes?
Yeah.
Thank you, Ms. Fuentes. No further questions at this time, Your Honor.
Any redirect?
No redirect necessary, Your Honor.
Okay. Does the prosecution have any further evidence or witnesses?
No, Your Honor, the prosecution rests.
All right, is the defense ready to proceed?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
Professor Van Owen, consider yourself sworn as you did before, and let's proceed.
Please state your name and then spell your last name for the record.
Professor Blake Van Owen, V-A-N space O-W-E-N.
And what do you do for a living?
I previously worked for the Aurora Police Department, and now I'm a private investigator, a professor, and I've consulted on more than 100 cases.
What's your educational history?
I was a police officer, and I have a master's degree in criminal justice, and I've taught a course on police procedures at the Community College of the Rockies, and at CU Denver, I've taught a course on police practices and social justice. I've been teaching for around 5 years now.
And are you familiar with courtroom proceedings?
Yes, I testify as an expert witness regularly before in the areas of police practices, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
And how long have you been in this line of work?
I've been a private investigator and expert witness for around 10 years. In the average year, I'll handle between 9 and 12 cases that are similar to this one in terms of my time commitments.
During an investigation, how do you form your opinions about a case?
As I say in my expert report, I review the police reports and investigation. All of my opinions are offered to a degree of reasonable scientific certainty based on my training, experience, and expertise.
Your Honor, I move to admit Professor Blake Van Owen as an expert witness in crime scene investigation, cell tower analysis, general police investigation tactics, and forensic evidence techniques, as her experience and education qualifies her to give an expert opinion under Rule 702.
What was the last category, counsel?
The last category was forensic evidence techniques.
Any objections?
Permission to voir dire, Your Honor.
Any objection to voir dire?
No objection to voir dire, Your Honor.
Go ahead, counsel.
Professor, you obtained your bachelor's degree in English at CU Boulder.
I did, but I also have a master's.
After that, you only served as a police officer for the Aurora Police Department for 9 months.
Yes.
Nonetheless, you consider yourself an expert for a job that you quit.
Yes.
You were never the lead detective of a homicide.
I was not.
Or a robbery.
No.
You were never the lead investigator in any case.
No.
You also never filed a case as a detective.
No.
You never testified as an expert when you were a police officer?
As a police officer, no.
You never completed any other advanced training through the police department?
Through the police department, no.
So all of your opinions on police procedure and tactics are based solely on your 9 months of firsthand experience.
This is my career. I've been doing it for more than 10 years. I know what I'm doing.
But you only have 9 months of firsthand experience as a police officer.
Yes.
Your Honor, the prosecution objects to this expert being admitted in the field of general police investigation, as this witness does not have the necessary firsthand experience and training as a police officer.
Defense?
Under Rule 702, a witness may be qualified by her education, training, or experience, of which this witness has testified to all 3. She has 9 months experience in the police force, but she has 10 years plus experience in this general field. And she has testified that general police investigation tactics is something that she concerns herself with over those 10 years as well.
So here's what I'm going to do. I am going to defer a ruling on that area of expertise until I hear what the defense intends to ask, at which time the prosecution may renew its objection to the area that is being examined as an expert. Okay, right now, I don't know whether it's even going to come up any questions about general police investigation techniques. So with that in mind, I am deferring my ruling, and both parties have a right to renew their positions.
Professor Van Owen, I'm going to start by asking you about this case in general. What is your connection to this case?
I was hired by the Becker family as a private investigator.
And are you familiar with the way that the police conducted this investigation?
Yes.
And what did you find about that?
This investigation was rushed.
Do you know any of the prosecution witnesses in this case?
Yes, I professionally know Kyle Kuzak, and I've been in more than one case handled by Detective Markowitz.
And do you see Ms. Kuzak here today?
Yes, Kuzak testified earlier with the other prosecution witnesses.
Are you familiar with her conclusions?
Yes, I reviewed them thoroughly.
And based on your expert review of those, do you agree with the conclusions?
Absolutely not.
And why not?
It's clear to me Detective Markowitz influenced Kuzak's findings. Cusack's entire report is based on assumptions such as how the murder happened, where the knife came from, and it also has misleading cell tower evidence.
Are you familiar with the evidence gathered by the police in this case?
Yes, I've reviewed it thoroughly as well.
You earlier mentioned the knife. What can you tell the jury about the relevance of the knife?
Cusack saw a knife block missing a knife and a knife wound and made the assumption that the two were connected. If she had looked a little close, she did notice that the knife brand and size is inconsistent with all other knives in the kitchen in the block and drawer as shown by Exhibit 7 and 8. It's more likely the murderer brought the weapon on scene.
You mentioned you disagree with Cusack on the issue of how the victim was stabbed. Can you explain those inconsistencies?
For Cusack's theory to work, the murderer would have to be much bigger than Mr. Brockman, but from the ring video evidence, that's not true. A much more logical explanation would be that the intruder stabbed the victim while he was seated. This theory also lines up with the autopsy report.
Let's move on to talking about the cell phone evidence. Are you familiar with the cell tower records?
I am.
And what do those records indicate?
To put it in simple terms, cell towers aren't like a GPS. In an urban environment, you can make 5 calls in the same spot, yet each of those calls could connect to a different tower.
And in your professional opinion, are cell tower records accurate?
No, the phone could have been at the house. It doesn't show that Avery was there. She was looking for her phone with Taylor, who was placed at the mall and Fry Shack.
Is this the only cell phone evidence that you've reviewed?
No, I've also reviewed text message screenshots from Alex Fuentes.
And what's significant about those screenshots?
They're only that, screenshots. The police have the technology to download the contents of smartphones. Police did no such thing, so we can't trust Alex didn't tamper with them. I take everything with 10 pounds of salt.
In your statement, you mentioned a Blair Rollins. Who's Blair Rollins?
Blair is Avery, Alex, and Taylor's fellow Colorado high school student.
And does she have a connection to this case?
Yes.
What's that connection?
In addition to the fact that Blair attended the same high school, Blair's father was represented by the victim, Mackenzie Brockman, in court. In fact, I investigated Blair Rollins as an alternate suspect.
Oh, why did you suspect Blair?
Objection, speculation. Pursuant to Rule 704B, in a criminal case, an expert witness may not testify as to whether a person had the motive to commit a crime.
May I respond?
Defense counsel, want to respond?
Yes, Your Honor. The witness, as an expert, is merely testifying to why she investigated Blair Rollins as an alternate suspect. And in a murder case, an alternate suspect is extremely relevant. I don't see where the speculation comes into this at all.
But your question is, why did you suspect Blair? Is that correct? Am I correct?
Yes, Your Honor.
So you're not asking her whether she investigated Blair, but why she thinks that Blair should be the accused in this case.
Yes, Your Honor.
I think you can rephrase the question, counsel. Let's see how we get to that.
Yes, Your Honor. Ms. Van Owen, what is Blair's connection to this case?
Well, Blair's father, Jonathan Rollins, was represented by Mackenzie Brockman, the victim, in court. And Blair's home is under the same cell tower as Avery Becker's.
Have you heard Exhibit 22?
I have.
Without going into its contents, please identify it.
This is a tape from Jonathan Rollins' court hearing.
Is it an accurate copy?
Yes.
Your Honor, I move to admit Exhibit 22 into evidence as its accuracy has been shown and its authenticity is stipulated.
Your Honor, I object to hearsay and speculation because there's no evidence that Blair Rollins heard this remark, and there's no evidence that he was present at the hearing. And if we cannot be certain, that Blair Rollins was at this, that Blair Rollins heard this statement, the prejudice outweighs the probative value.
May I respond, Your Honor?
Yes.
This
Go
is
ahead.
actually, this meets neither requirement of hearsay, Your Honor, as it's number one, not an out-of-court statement, as it's a statement in court at the hearing of Jonathan Rollins. And number two, it's not offered for the truth of the matter asserted as an offer of proof. The matter asserted is something that Jonathan Rollins said, and we are not investigating discussing Jonathan Rollins here. We are discussing his daughter, Blair.
Your Honor, I believe this audio recording is asserted for the truth of the matter, and also this is an out-of-court statement because it is not made in this court, but rather in another court.
Right, at this point, I would ask counsel to approach the bench. At the bench, I'm asking counsel, what is the statement in the recording? What is that statement?
The statement in the recording is Jonathan Rollins saying that he would get back at Mr. Brackman, and we are not offering it for the truth that Jonathan Rollins got back at Mr. Brackman.
And you are offering it for what reason?
To prove the motive of Blair Rollins.
However, the hearsay objection has not been addressed, Your Honor.
This is the hearsay objection.
Well, okay, so the hearsay, okay, you can take your seats at counsel table. All right, as to the hearsay objection, it is an out-of-court statement because it's not a statement being made in this court, is it? Isn't that the definition of hearsay to start with, that hearsay are statements that somebody makes outside of taking the witness stand in this courtroom?
Yes, Your Honor.
Yes, Your Honor. But
Okay.
the second part of hearsay still applies, of the hearsay still applies.
And why then, therefore, is it admissible? Because it's not being offered for the truth? Is that what you're saying?
Yes, Your Honor, it's not being offered for the truth of the matter asserted.
And how do you address my concerns over Rule 403 that raised by the prosecution, that the statement itself could be so prejudicial in terms of the outcome of the case?
The probative value outweighs its prejudicial, as the expert Blake Van Owen is testifying to its authenticity and its relevance in this court today, and its probative value to an alternate suspect.
I'm going to sustain the objection. It's not admitted. Your microphone, counsel.
Professor Van Owen, moving on, in your professional opinion, does this evidence that you found and analyzed establish the prosecution's case?
The prosecution did a sloppy job. Their entire case rests on assumption after assumption, inconsistency after inconsistency, which don't make a case. Avery has a solid alibi. She and Taylor were looking for the missing phone.
Thank you, Ms. Van Owen. No further questions at this time, Your Honor.
Cross-examination,
Yes, Your Honor. May I proceed?
please.
Professor, you stated you were disillusioned with police work after you quit your job as a police officer because a woman sued you in the APD.
Yes.
Consequently, you like to think of yourself as a check on the power of the police.
I do.
You've only been an expert for the defense, never the prosecution.
That's correct. The prosecution likes to use free law enforcement personnel and, well, you get what you pay for.
You've stated that you make a decent living revealing where the police have dropped the ball.
I do.
You charge $225 for investigation work and $450 per hour for court testimony.
That's correct.
So if you opine that the prosecution failed in their process, as you are opining today, the case is more likely to go to trial.
I am paid for my time, not my opinion.
So if the case goes to trial, you make $215 more per hour.
Yes.
And you've already charged $7,000 today.
So far.
You also expect to make another $1,000 right as we speak.
Yes.
So if you imagine when you're cutting food with a knife on a cutting board, the blade is pointing down, right?
Yes,
And yet you claim the blade was pointing up when Brackman was stabbed.
I do, if I'm allowed to explain my reasoning.
Well, you've stated that the knife construction itself can affect how the user will hold it.
Yes, exactly. When you're cutting vegetables on a cutting board and the blade's down, you're holding a knife like this. But if you're holding the knife in an overhead fashion, your fingers could be on top and holding the blade like that. The blade is pointed upwards.
Aren't kitchen knives, such as the murder weapon used in this case, designed to have the blade pointing down?
It's designed to be held a certain way. How you hold it affects how the knife blade is positioned.
You actually stated that it would be more common for the knife to be held in reverse position from what you claimed.
Yes, but that's not what's happening here.
You believe that Brackman was seated, not standing when he was stabbed.
I do.
And as you stated in your expert report that you mentioned, you stated the ring videos show the intruder was of similar build to Mackenzie Brackman.
Yes.
So if the intruder and the victim were of similar build, isn't it plausible that the intruder could have easily raised their arm above Brackman's back to stab him?
It's plausible, but it's not my expert opinion.
Thank you. You weren't part of the PD team that investigated Brackman's death.
Could you re-ask your question? You cut out a bit.
You weren't a part of the police department team that investigated Brackman's death?
I was not.
You weren't at the crime scene?
No.
You didn't collect any evidence?
I did not. That's the prosecution's job.
You didn't conduct any witness interviews?
I attempted to, but no.
You couldn't assess the truthfulness of any of the witnesses?
Not on my own.
You only looked at the investigation of the murder in hindsight?
Yes.
You could have obtained those cell tower records from the day prior to the murder, but you didn't.
I could have, but once again, it's not my job.
So that's a yes, you didn't obtain those records?
I did not, and the police also did not.
You admit that you should have obtained those records.
I should have, but it's the police's job.
And yes, I have no further questions. Thank you, Your Honor.
Redirect?
Yes, Your Honor, briefly. Professor Van Owen, why didn't you obtain the cell tower records?
Well, it's the job of the prosecution to establish their case beyond a reasonable doubt. It's not my job to collect evidence.
So then what was your job in this case?
My job was to analyze the police's investigation and how they did, and they did a bad job.
And what did you find from this investigation?
I found that it's based on assumptions and inconsistencies. Avery has a solid alibi. She wasn't there.
Thank you, Ms. Van Owen. No further questions, Your Honor.
Recross?
No recross at this time. Thank you, Your Honor.
All right, witness excused. Okay, let's have the next defense witness, if there is one.
The defense calls Taylor Perkins to the stand, Your Honor.
Okay, Taylor Perkins, you have been sworn. You may testify.
Good morning, Ms. Perkins. Please state your name, spelling your last for the record.
Taylor Perkins, Perkins.
Why are you here today, Ms. Perkins?
I'm here because in an interview with police, I said that Avery and I were together the entire day on March 6th, 2020.
And what is your connection to the people involved in this case?
At the time, I was a senior at Colorado High School with Avery Becker, my best friend. We were on the mock trial team together, and let me tell you, we rocked our 2020 virtual graduation.
What is mock trial?
In mock trial, high schools compete against each other in a sort of fake court case. Mr. Brackman was our coach, and our team always did amazing and won plenty of awards, especially Avery.
What kind of a teammate was Avery?
Well, Avery was never super prepared, but didn't have to be. Avery was still always there for the team and did an amazing job. She was still the best lawyer on the team by far.
How did people on the team get along, from what you observed?
From what I observed, for the most part, everyone got along fine, but there was some tension.
Objection, speculation.
Response, Your Honor.
Response?
I asked the witness how, from what she observed, it's rationally based on the witness's perception.
Repeat the question, counsel.
From what you observed, how did the people on the team get along?
Your Honor, may I respond?
Yes.
The witness did not testify to the actions of the team, rather how the witness assumed they were getting along with each other, but the witness did not describe their interactions.
All right, so you're saying that there's an inadequate foundation to ask that question?
Yes, Your Honor.
Okay, so do we know that she actually observed counsel of defense?
Yes, Your Honor. The previous line of questioning was about mock trial and establishing that she was on the team and was interacting with members of the team, including Avery. So.
All right. Then the objection is overruled.
Would you like me to re-ask the question, Ms. Perkins?
Sure.
How did the people, based on what you observed, how did the people on the team get along?
Based on what I observed, everyone got along fine on the team, but sometimes there was a little bit of tension.
What do you mean?
Well, Avery didn't necessarily get along with everybody on the team well, specifically Alex Fuentes and Coach Brackman. To me, Avery never told me that she was too serious about it though. And she always meant well, and it was always just pranks anyway.
Objection, speculation.
Response, Your Honor.
You're objecting to the question or the answer?
The answer, Your Honor.
Okay, is the answer non-responsive?
The witness testified about how Avery felt, and that is a speculative statement.
Response, Your Honor.
Yes, go ahead.
The witness's response was based off of what she observed, and she used words such as never seemed based off of what she appeared to look like to Taylor. So it's all based off of her observation of the situation. She isn't saying what Avery did for in fact feel.
All right. Had the court reporter chosen to show up today, and the court reporter did not choose to show up today, I would ask the court reporter to read back the witness's answer. But at this point, let me hear the witness if she remembers what she said. Otherwise, we'll strike. Well, okay, you do remember. Okay, let me.
Yeah, I think so. I said that Avery always felt so bad from what I could tell. I mean, I could just tell how remorseful and how she didn't get along with everybody on the team, specifically Alex Fuentes and Coach Brackman. To me, Avery never told me that she seemed too serious about it, though.
Yeah, I think that goes beyond what the testimony. So the witnesses said that Avery felt. Now, this would be, improper, not based upon speculation, but an improper, well, in part speculation and an improper conclusion. So let's see if we can't get a little bit more about what this witness observed. Counsel?
Yeah. From what you observed, let's just reset that. Could you elaborate on the tension you mentioned previously?
The tension between the team was mostly between Alex Fuentes and Coach Brackman and Avery, from what I saw. On the team, Avery never seemed too serious, and she never told me that she meant harm to anybody. She always meant well, and it was always just pranks anyway.
From what you observed about Avery and through your friendship, how did it seem Avery? What did you observe about Avery's response to the tension?
Avery always told me that she felt so bad. I mean, I could just tell how remorseful she was after anything happened. One time that stuck out to me about this was after the car incident after regionals. She told me how much she regretted doing it, and it was obvious to me that she really meant this.
How was it obvious?
Avery would do anything for the team. She really would.
I would now like to discuss Thursday, March 5th, 2020. What happened that day?
After Avery had been kicked off the team, Avery showed up to mock trial practice to try and talk it through with Brackman, but was told to leave. Avery then came to my house where we hung out and played games on our phone for a while. Then we went to get something to eat at the Fry Shack. But that turned out to be sort of a bad choice.
Why was the Fry Shack a bad choice?
Well, shortly after we got there, the majority of the mock trial team came in after practice. Alex was with them, and Alex and Avery don't really get along very well.
So then what happened?
Everybody was telling Avery how unfair it was that the coach kicked Avery off the team, even Alex Fuentes.
Objection hearsay.
Response, Your Honor?
Yes.
It's not asserted to the truth of the matter. It's not for the truth of the matter asserted.
And what's it asserted for?
We're just laying foundation for the events of March 5th, 2020.
Okay, foundational. The response from prosecution? It's foundational.
Your Honor, it's still an out-of-court statement, and it's going to the relationship between the team and Avery, which does go to the truth of the matter and to tension and motive.
Your Honor, response?
Yes.
It's not offered to the truth of the matter asserted, though. It's there's nothing in here relating to the actual truth of the matter.
Well, then we got a relevance problem. I'm going to sustain the objection. Continue.
Of course. So, what happened at the Fry Shack?
At the Fry Shack, Avery got upset after everybody was telling her these things, and she stormed off to the bathroom. Her phone was still sitting on the table, which kind of showed how upset she was.
Let's talk about that next day, March 6th. Do you know where Avery was that day?
Of course, Avery was with me the entire day. She had lost her phone the day before, and so we spent the day looking for it together.
Could you please walk the jury through the day starting with that morning?
Yes, Avery picked me up at my house that morning. She hadn't answered any of my texts that morning, but we always rode together, usually in the mornings, so it wasn't a problem. But when I mentioned the text, when I said something about it, we realized that her phone was missing.
What happened next?
We decided to go looking for it. We didn't really have to be at school that day, so we went to search for her phone instead. We retraced all of our steps, and I called and texted her phone the entire time, but we had no luck finding it.
So after Avery picked you up, where did you go?
We first went to the mall and checked every store that we had been in the day before. We didn't find it, and that's when I remembered Avery leaving her phone on the table at the Fry Shack, so we went there next.
Who did you encounter during your search for the phone?
We saw tons of people. We talked to multiple store clerks and staff at the mall, and the afternoon shift staff at the Fry Shack even helped us look for the phone. We were very busy that day, looking in every place that the phone could have possibly been.
How long did you and Avery spend looking for the phone?
We burned all day. Most of it was spent at the mall and then the Fry Shack that night.
Did anything stand out to you about the Fry Shack?
Well, not at the time, but reflecting back to why I'm on the stand in the first place, yeah.
What did you see?
The mock trial team showed up while Avery and I were looking for her phone.
Why did this stand out to you?
Because they should have been at practice at that time, but apparently Mr. Brackman never showed up, so they left after 15 minutes. It's weird now to think that Brackman was dying while we were talking about him there.
I would now like to ask you some questions about Blair Rollins. Earlier, Professor Van Owen mentioned a student named Blair Rollins. Do you know her?
Kind of. Blair was also a senior at Colorado High School. She had a pretty well-known reputation around school.
What reputation is that?
Blair had kind of a thing with Brackman. Everybody knows that Blair hated Brackman for losing the case for sent Blair's dad to prison.
Objection, lack of foundation.
Sustained. You want to respond, counsel?
Yeah. In the previous question, we'd mentioned we'd established that Professor Van Owen set the tone for who Blair Rollins was. And also in the previous question, we also said that, the witness mentioned that Blair had a pretty well-known reputation around school. So that foundation was set.
Well, but the witness's answer was, if I recall, that she said everybody knew that Blair hated Brackman. Am I right?
Yes, Your Honor. Response, May. In the previous response, she had mentioned Blair had a pretty well-known reputation around school, so it set the tone that the whole school knew this reputation very well about Blair.
Your Honor, may I
And
respond?
Yeah, go ahead, counsel.
Your Honor, there wasn't enough foundation to establish how the witness heard this information, even if it was Blair Rollins' reputation at the school, there still wasn't foundation laid as to how the witness acquired this information.
Response, Your Honor?
Yes.
It was established that Blair was also a senior who Taylor Perkins knew. The first question being, do you know Blair Rollins? And the witness responded with, yes, she was also a senior. And that she had a well-known reputation around school, a school that she attended.
We don't know if this witness has heard words out of Blair's mouth about Blair's attitude, or whether this witness has talked to Susie or John or Mike about Blair and Brackman. That's what we first have to establish to know how this witness can say she knows about how Blair felt about Brackman. So I'm going to sustain the objection, but you can try to lay your foundation, counsel.
You mentioned knowing Blair Rollins and a reputation. How did you know about this reputation?
This reputation was known throughout the school. When it happened, I heard it through the grapevine. Everybody knew about it.
And what exactly did they know from what you heard?
Well, from what I heard, they knew that Blair hated Brackman for losing the case that sent Blair's dad to prison.
Your Honor, objection foundation. Again, there still hasn't been sufficient foundation laid as to how the witness heard this information or who she heard it from.
Response, Your Honor?
Yes, go ahead.
Taylor has just mentioned that that she heard it through the grapevine, and that what she heard through the grapevine was this. So some foundation has been set.
Let me ask you, don't we have a hearsay problem?
That's a separate objection.
Yes.
Objection, Your Honor.
It is. How would you meet that, counsel?
Your Honor, this questioning is relevant to our contention that there was an alternate suspect, and that is admissible under 405A. And it's not offered for the truth of the matter asserted, Your Honor.
Prosecution want to be heard?
Yes, Your Honor, this statement is definitely being used for the truth of the matter as it goes to someone else's another motive to kill Mr. Brackman instead of Avery, and this goes to their theory of the case.
Response, Your Honor?
Yeah.
As previously mentioned, this is admissible under 405A because this is providing evidence of a person's character by testimony, and this is to help support our contention of an alternate suspect.
Well, I mean, reputation as to attitude is really not a character trait in any way, shape, or form. And it's really not a reputation issue either. It's a projection, is it not, of this witness's perception of how Blair felt, hearing other people say how Blair felt about Brackman. So I'm going to sustain the objection.
What is Blair's friend group?
I'm not entirely sure who Blair hangs out with, but I do know that Alex is pretty close with Blair.
What is Blair's body build like?
It's actually very similar to Avery's build. They look almost identical.
I just have some final wrap-up questions. Based on your knowledge of Avery, is Avery capable of this?
Look, Avery could be rash or have an inflated ego at times. but Avery definitely wasn't irrational enough to commit murder. And she couldn't have committed this murder because Avery wasn't there. We were looking everywhere for her phone.
Would you lie for a friend?
Absolutely not. And it doesn't matter what I'm saying because there's proof that I'm telling the truth. There are plenty of people at the fry shop that saw us and at the mall.
No further questions, Your Honor.
Yes, okay, any cross?
Yes, Your Honor. Ms. Perkins, the defendant Avery is your best friend.
Yes, I'd say she's my best friend.
She's one of the reasons you did mock trial.
Yes.
And you were both very good at mock trial.
Yes, we were.
Which requires you to make things up on the spot.
It does.
Objection, Your Honor. Relevance?
May I respond, Your Honor?
Yes, go ahead.
Your Honor, this goes to credibility and Avery's credibility.
Response, Your Honor.
Yes.
I fail to see how Taylor's ability to perform at a club team at her high school affects this trial or this case.
I'm going to overrule the objection. You may proceed, counsel.
Ms. Perkins, mock trial requires you to make things up on the spot.
You could say that, yes.
So essentially, it requires you to be very good at acting.
Possibly.
And Coach Brackman gave Avery a hard time for giving little effort.
Yes.
And for being unprepared.
Yes, he did.
And for being late to practice.
Yes, sometimes.
In fact, because of those things, Avery was demoted to B team.
Yes, she was.
Which made her angry.
Yes, it did.
Objection, Your Honor. That question called for speculation.
Sustained.
Because Avery got demoted, you quit A team in support of your friend.
I did, but that wasn't the entire reason. I didn't love mock trial anyway, and I thought that Avery deserved the spot more than me. I quit for myself as well.
But you did it so that Avery could move back up to A team.
I did it partly because of that, yes.
Which was manipulating Brackman.
I don't see how it was manipulating Brackman.
Well, okay, you also admit that Avery and Brackman had a feud.
Yes, I do.
Which you found funny.
I did, yes.
But Avery didn't find the feud funny.
Objection, Your Honor. Speculation.
Sustained.
In fact, Avery was bothered enough to play some pranks on Brackman.
Yes, she was.
Speculation. There's no way this witness knows that the motive of Avery.
Well, the witness answered the question, so the witness is saying she knows. Overruled.
In fact, Avery was bothered enough to play some pranks on Brackman.
Yes, but they were just that, pranks.
But Avery impulsively reacted to things sometimes.
Sometimes.
In fact, when Brackman told her she didn't deserve the award she won at regionals, she wrote Worst Attorney Award on his car in permanent marker.
That's what she told me, yes.
So at least one of Avery's pranks caused serious damage.
It did, but at the time, she didn't know that. She didn't mean for it to cause any damage.
This was irrational.
It was.
And if she's irrational enough to ruin his car, she's irrational enough to pull a prank at his house.
Objection, Your Honor. Speculation.
Sustained.
Avery's phone is like her third kidney.
I mean, I don't really understand the whole third kidney thing. I know I said it, but nobody needs a third kidney. Nobody even has a third kidney.
Well, Avery's phone is never out of reach.
This is a little bit of an exaggeration. I would say that she likes her phone just as much as any other teenager, but yeah.
However, you stated that her phone is never out of reach.
I did say that, yes.
And you stated that she may have left her phone at the fry shack the day you saw the mock trial team there.
Yes, I do believe she did.
But you're not sure.
I'm not positive, although I do remember her leaving her phone there.
So you admit that Avery could have had her phone after both of you left the fry shack.
I seriously doubt it, but sure.
Because it's like her third kidney, it's also unlikely Avery, a teenager, forgot her phone for the entire rest of the day, which is around 10 to 15 hours.
I don't think this is very unlikely, no.
In fact, she didn't remember losing her phone until the next day when you brought it up.
That's true.
Because it actually didn't happen.
That's false.
Once you allegedly realized her phone was missing, you then both spent the entire day looking for it.
Yes, we did.
Yet neither of you ever thought to use Find My iPhone.
No, I don't. I have an Android, so I'm not familiar with that technology as much, and it didn't come to my mind.
However, Avery, who is very used to using a phone, didn't think to use Find My iPhone, but thought that texting a phone that could be very far away or in a noisy mall was a good idea.
I don't know what Avery thought was a good idea.
But wouldn't someone so attached to their phone know how to find it easily?
Maybe.
And since it's unlikely Avery forgot her phone, it's unlikely Alex was able to get it and make up those text messages.
No, I wouldn't say that.
In fact, in your statement, you admit that Alex helping Blair Rollins kill Bracklin is a stretch and unlikely.
I wouldn't say that now.
But you did say it in your statement, correct?
I did say that in my statement, yes.
You also state that Avery performed flawlessly while making things up on the fly.
At mock trial, she did.
Relevance.
May I respond, Your Honor?
Yes.
Your Honor, this goes to credibility again.
Your response, Your Honor.
Yes.
This line of questioning has nothing to do with the question. And again, it's not relevant what Taylor or Avery were able to do in mock trial. That doesn't affect the case here today.
Well, I believe counsel is trying to cast a question about credibility, but since we have not heard from defense, and we don't have to hear from defense, that's certainly defense prerogative, this question is premature, and I'm going to sustain the objection.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor, briefly. Taylor, where were you on March 6, 2020?
We were at the mall the entire day. We were together and we saw plenty of people. We were looking for her phone, which wasn't with us, and we had no idea where it was.
No further questions, Your Honor.
Recross?
No, Your Honor.
Okay. Does the defense have any other witnesses?
We do, Your Honor. The defense calls Avery Becker, the defendant, waiving her right to remain silent, to the stand.
Okay. Ms. Becker, you've been sworn. Proceed, counsel.
Ms. Becker, could you state your name and spell your last for the record?
Avery Becker, Becker.
Thank you, Ms. Becker. Can you tell the jury a little bit about your interview with the police?
Yes, I believe Cusack shared Exhibit 17, I believe. In there, it stated that I told police about my alibi with Taylor the day of the murder, and it also stated that I told them about how I lost my phone.
Now let's go into a little bit about your character. Can you tell the jury a little bit about yourself?
Yes, I was on the mock trial team for 4 years, and I was a senior at Colorado High School last year. I absolutely loved being a lawyer on that team.
And was anyone else in the courtroom today a part of that team?
Taylor, Alex, and Coach Brackman used to be. Unfortunately, he's no longer with us.
Can you elaborate for the jury on who Alex is to you?
Well, as Alex previously stated, she was jealous of my mock trial. She is jealous of my mock trial charisma, I guess you would say. And I kind of felt this jealousy, so it kind of made a drift. So we didn't really like each other, nor did we get along.
And what was your friendship with Taylor like?
My friendship with Taylor was awesome. She's a great best friend. And she was the initial reason I joined the team, but not the reason I stayed on.
What do you mean by best friend?
Well, she was willing to skip school the entire day to help me search for my phone that I'd lost.
Can you elaborate on your relationship with your late coach?
Yeah, Coach Brackman always wanted things done up front, right then and there. But I really liked to just go with the flow of the courtroom, and I proved to be very good at it. I liked giving good crosses and then give really great closings. And then I won awards for that.
And what did this difference in opinions lead to?
Well, I was on A team and he demoted me down to B.
What happened after you were put on B team?
After I was put on B team, Taylor told me that she really didn't feel like she liked mock trial anymore, and she knew the team needed me, so she stepped down.
So what was the result of this action?
Coach Brackman moved me back up to A team.
And so how did that go?
Well, it went very well. At regionals, I won 2 awards. Last year, the case problem was about these old people fighting about their will, and the mom always dressed up the corgi. You should have heard the way I described that corgi in my closing. I guess you could say that I was the best in show. I had them feeding out of my paw. Sorry, I like dad jokes.
So how did Brackman feel about you winning these awards?
Brackman started in on his little critique, and he made it clear he felt they were undeserving. This made me so upset, and I did something astronomically horrible.
What did you do?
I wrote worst attorney on the hood of his Porsche. I've done some dumb things in my life, but that had to have been the dumbest.
How did you feel after this event?
After this, I tried to apologize to him. I went in person. I offered to pay back. I offered to repaint his car, and I even offered to get it off myself. He ignored all of my apologies, and I was still kept off the team because of it.
So let's bring the jury to just before the 6th of March. Can you describe your activities on the day before, on the 5th?
Yeah, so on the 5th, I went with Taylor to the Fry Shack, and we hung out with a couple of mockers, and then we hung out at the mall.
And so what happened on the morning of the 6th?
I woke up and I was searching everywhere for my phone, and I realized I didn't have it.
What did you do about that?
So I went and picked up Taylor, and we were off searching for it.
Where did you start?
Well, we first started at the mall. We looked around a couple of stores. I'm sure I looked in a couple of plants, and then we were off to go look for it at the Fry Shack.
So how long did you and Taylor spend looking?
We spent the entire day searching for my phone.
What other measures did you and Taylor take to find that phone?
Well, Taylor called my phone several times, so maybe we could locate it, but we were unable to.
Now I'd like to move on to some of the testimony you heard earlier in this trial. What was your reaction to the Markowitz's testimony on the cell phone tower data?
Honestly, if I would have known that my phone was anywhere near those cell towers, maybe I could have found it and didn't have to waste an entire day searching for it. But in all respect, I didn't have my phone that day, so it may have pinged at those cell towers, but I'm not my phone.
And what was your reaction to hearing Alex Fuentes testify that you sent her texts?
I never sent Alex texts. Alex would not have helped me for anything. And like I said, we didn't really get along. So I would never have texted Alex those text messages.
Of course. Now I'd like to move on to Blair and discuss Blair Rollins with you. Did you hear Professor Van Owen testify?
Yes, I did.
Are you acquaintances with Blair?
No, I don't really know Blair. I've seen her hang out with Alex, but that's about it.
Is Blair in the courtroom today?
No, from Van Owen's testimony, I understand that she disappeared.
And you saw a series of ring videos presented by the prosecution.
Yes, I did.
Are you in those videos?
Absolutely not. I hate that outfit. I would never wear a devil mask. I've always been an angel for Halloween. And second off, on March 6th, I was looking for my phone everywhere with Taylor Perkins.
Miss Becker, did you kill Coach Brackman?
Absolutely not. After the whole car incident, I would have never done anything to hurt him. I felt horrible, and I wanted to apologize in person, but I'm never going to get that opportunity. I could never do anything after that whole car incident.
Your Honor, no further questions.
Cross-examination.
Yes, Your Honor. Mock trial came very easily to you.
I would say that I have a natural talent, yes.
You could spin a yarn that had those scoring judges like putty in your hands.
Objection, Your Honor. Improper character evidence under Rule 404A1.
May I respond, Your Honor?
You may.
Under Rule 404B, this is admissible for the purpose of identity, and other acts can be used to show opportunity or intent.
So the question was about repeat the question.
The question was, you could spin a yarn that had those scoring judges like putty in your hands, which was in line 16 of Ms. Becker's statement.
So do we have is that part of a personality or a character that's spinning something like people like putty in hands?
It goes to the witness's credibility.
Aha, okay. It goes to the witness's credibility. Okay.
Response, Your Honor.
Yes.
They would be testifying to the witness's persuasiveness as a character trait, which under 404A1 is impermissible, as they would be using this evidence from a long time ago to prove that the witness acted in accordance with that trait today.
It's overruled. Question shall be admitted in the end. The witness may answer.
Thank you, Your Honor. Ms. Becker, would you like me to restate the question?
Yes, please.
You could spin a yarn that had those scoring judges like putty in your hands.
More specifically, I was talking about my closing, and that doesn't really...
Yes or no, Ms. Becker?
Well, in my closing, I said that, so yes.
Spinning a yarn is a nice way of saying lying.
Objection, Your Honor. This is not from the witness's statement. And incorrect.
So are you arguing this is extrapolated? It's calling for extrapolated? What is the?
Yes, this is extrapolated, an extrapolated statement because the opposing counsel has no knowledge of whatever Ms. Becker had in her closing and whether or not that was somehow lying about mock trial.
Problem is a lack of foundation. Why don't you repeat the question? I think I'm going to overrule the objection, but let's hear the question again.
Spinning a yarn is a nice way of saying lying.
Yeah, yes. The objection's overruled.
Thank you, Your Honor. Ms. Becker, would you like me to restate the question?
Yes, please.
Okay. Spinning a yarn is a nice way of saying lying.
No.
It's manipulative.
No.
Mr. Brackman didn't approve that you did things that way.
He didn't like how I often would improvise.
He never gave you credit for your accomplishments.
He never gave anyone credit for their accomplishments.
You argued frequently with Mr. Brackman.
We argued together, yes.
You thought he was full of himself?
I did.
You hated him.
Actually, I, in my statement, said that Blair Rollins hated him more than I did.
Miss Becker, on line 138.
I'm sorry, I'm not done. I hated him a little bit, but not nearly as much as Blair Rollins did.
Miss Becker, that is implying that you hated Mr. Brackman, though.
In some ways, yes.
Thank you. At one point, you were even demoted to B team.
I was.
You were rescued because of your best friend, Taylor Perkins.
I wouldn't say rescued. She didn't like it nearly as much as I did, and she knew the team needed me.
Taylor would do anything for you.
Objection,
No.
speculation.
Sustained.
Taylor Perkins skipped an entire day of school searching for your phone with you at the mall.
Yes, but she knew that it was important to me, and she's a good friend. That's all.
No one can verify here today, except for your best friend, that you were genuinely at the mall on March 6th.
Well, there was people at the mall and the fry shack. It's not my job to bring in those people. It's the prosecution's job.
But Miss Becker, there is no one here today except for Taylor Perkins.
Unfortunately, no.
You claim you left the fry shack without noticing your phone wasn't with you.
Yes, oftentimes when I got home, I was unable to use my phone, so I was pretty used to not having it. So
Thank you, Miss Becker. The whole time you're at the mall, you still didn't realize it was missing.
No, I was just having a good time with my best friend.
And as you just said, your parents take your phone every night until your homework is done.
Yes,
Yet you claim you didn't notice it was gone that entire evening.
no, I was hanging out with my best friend. There was no need for phones.
You claim you didn't realize it was missing until you actually picked Taylor up for school the next day.
Actually, in my statement, I say I woke up and realized I was missing and looked around. Then Taylor reminded me in the car.
Yes, when you went to go pick up Taylor for
Yes.
school. Yes. Let's go back to when you rejoined A team. You won Best Attorney and closing at regionals.
I did.
Even then, Mr. Brackman lectured you at practice.
Unfortunately, yes.
This made you mad.
It made me upset.
It caused you to lash out.
We were giving back insults, but that was pretty common between us. I wouldn't say lash out.
Well, you did go and then vandalize Mr. Brackman's car.
Yeah, it was a spur of the moment thing, and it was so dumb on my part, and I feel horrible about it.
You took the object you knew he loved and purposely wrecked it as revenge.
I wouldn't say revenge. It was a spur of the moment thing. I saw the car, and I just blanked out and did it.
This made Mr. Brackman enraged.
It did.
He screamed at you in the middle of the parking lot.
He did.
He then kicked you off the team permanently.
That's true.
The next day, you went to his office to apologize.
I did. I felt absolutely horrible about it.
He refused to talk to you.
Yeah, unfortunately, he did.
This made you even more upset.
It did make me upset, yes. But
So,
it didn't matter because I texted him and apologized, and that was the most I could do.
So you were so upset, you went to Brackman's house to get payback again.
Absolutely not.
You thought he would be at work.
No.
Objection, this is unfair extrapolation.
Overruled.
You thought he would be at work.
No.
Let
right
me go back and because of the nature of the uniqueness of this court, you're objecting to extrapolation. I'm going to advise the panelists. I'm not going to overrule it. We're just going to proceed, but I'm going to advise the panelists that they have options of making a determination about whether or not it is extrapolation or whether it flows from the known testimony of the witness, and whether they want to use that decision about extrapolation and how they are going to score. But it stands, and you may, Counsel Cross, you may proceed on that basis.
Thank you, Your Honor. You thought he would be at work.
Absolutely not. I was at the Fry Shack the entire day. I didn't send Alex those text messages. I was at the Fry
Ms.
Shack.
Becker, I didn't ask about
And
the
I
text
were looking
messages.
everywhere. I'm sorry, what did you say?
I didn't ask you about those text messages.
I'm just elaborating on this.
Ms. Becker, thank you. You walked right into that house.
No, absolutely not. I was at the Fry Shack.
He surprised you.
No, I was at the Fry Shack the entire day.
You two physically fought and then you stabbed him.
Are you kidding me? Absolutely not. I was at the Fry Shack the entire day with Taylor Perkins.
Ms. Becker, as you stated on line 104 of your statement, you told your mom you would get back at Brackman if it was the last thing you ever did.
I said that as a spur of the moment thing.
I did say it, Ms. Becker.
I'm sorry, can you repeat?
Yes, you did say that.
I said it, but I never meant it.
Thank you. I have no further questions.
Redirect.
Yes, Your Honor. Ms. Becker, in reference to that last statement, when did you make that statement?
I made that statement after I wrote on the car. I was upset, I was hurt, and I didn't mean it. I knew I had to apologize to him after talking to my mom, who was amazing. So I did that. I never broke into his home, and I never would.
And how did you feel the day after you made that statement?
I felt horrible. That's not what I wanted at all. I wanted to apologize and get back on the team. Breaking into his home would have never done that.
Did you do anything between the time when you made that statement and when Brackman was found dead?
Yes, I was at the Fry Shack the entire day looking for my phone with Taylor Perkins. There was people at the mall that said that we were there, that could have said that we were there. There's people at the Fry Shack that could have said we were there, and yet none of them were brought in. I was there the entire day.
For the sake of clarity, were you asked on cross about anything that wasn't in your statement?
I think it was the entire cross, or maybe a majority of it, yes.
Your Honor, no further questions.
Any recross?
No, Your Honor.
All right. Does the defense have any further evidence?
We do not, Your Honor. The defense rests.
All right. Is counsel prepared to proceed with closings?
Yes, Your Honor.
Okay, we'll hear the prosecution. And how much time are you reserving for your rebuttal?
I reserve any time remaining for rebuttal within the 5 minutes of allotted time.
All right,
May I proceed, Your Honor?
you may proceed.
It was payback gone wrong. On March 6, 2020, Avery Becker broke into Mackenzie Brackman's house. Avery wanted to cause some trouble, shake Brackman up, and get revenge. Maybe Avery didn't intend to kill her coach that day. Nonetheless, Mackenzie Brackman ended up lying face down in a pool of blood, dead. Your Honor, members of the jury, the people proved beyond a reasonable doubt, based upon all the evidence, that Avery Becker committed second-degree burglary and murder in the first degree, otherwise known as felony murder, on March 6th. When Avery was upset over an argument at practice, she wrote "Worst Attorney Award" on the hood of Brackman's car in permanent marker. That day, Avery showed us who she really is: impulsive, vindictive, and malicious. When Avery was permanently kicked off the team, she wasn't just upset. She was enraged. She decided to go to Brackman's house and trash it to get payback. Maybe she didn't think he'd be home. Maybe she didn't think he'd be armed with a knife. Maybe she wasn't thinking at all. It was payback gone wrong. Now, Avery denies she was at Brackman's house on March 6th because, according to Avery and Taylor Perkins, Avery's alibi witness and best friend, they were looking for Avery's phone all day, which we heard was like her third kidney. The defense wants you to believe that Avery lost her phone on March 5th and didn't realize it was missing until the next day. Use your common sense. We know Avery's parents took her phone every night. Also, what teenager can survive without their phone for a whole night? The evidence shows that there were both texts and calls from Taylor to Avery's phone on the day of the murder. However, no one sends a text to find a phone, especially in a noisy mall or burger joint. As everyone knows, you use the app Find My iPhone. As everyone also knows, Taylor would do anything for Avery. Remember, Taylor quit the A-team so that Brackman would have to take Avery back. What would Taylor do to keep Avery out of prison? The defense's expert wants you to believe that Blair Rollins committed this heinous crime, but the defense introduced no material evidence whatsoever that could possibly link Blair Rollins to this crime. The people have proved through our witnesses that Avery Becker broke into Brackman's house and killed him, whether she meant to or not, which is felony murder. Alex Fuentes testified that Avery texted that she was going to break into Brackman's house and trash it, which constitutes the felony of second-degree burglary. In Avery's words, that'll show him. Detective Markowitz proved that Avery was in the area of Brackman's house at the time of the murder. The texts and calls showed Taylor was desperately trying to get in touch with Avery, who was not responding because she was at Brackman's house. The crime scene photographs are evidence of a struggle, which Kyle Cusack confirmed. The evidence shows that in the end, Avery fatally stabbed Brackman. Only Avery knows if she entered that house with the intent to kill. But her intent to kill doesn't matter. What matters is that while committing the felony of second-degree burglary, Mackenzie Brackman ended up dead, lying in a pool of his own blood. It was payback gone wrong. Members of the jury, we ask you to find Avery Becker guilty of the murder of Mackenzie Brackman. Thank you.
All right. Defense.
Yes, Your Honor. Avery wasn't there. She and Taylor were looking everywhere. My name is Jessica Bustillos, representing the defendant Avery Becker in this case here today. We are all here to make sure that justice prevails. On March 6th, Avery noticed that her cell phone was missing. While someone else was killing Coach Brackman, Avery was with Taylor looking for the phone. She was nowhere near the Brackman house and did not kill her coach. Avery wasn't there. She and Taylor were looking everywhere. It is important to remember the jury instructions while looking at this case. Jury instruction number 2 reminds us that the burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. The prosecution has failed to do that, and they have failed for one simple reason. You cannot find an innocent person guilty of crimes they did not commit. Jury instruction number 2 also says every person charged with a crime is presumed innocent. And jury instruction number 6 reminds the jury that assumptions made by experts are still just opinions and not facts. You may believe some, all, or none of a witness's statement. The reason these jury instructions exist is because we don't want an innocent person to get convicted. I urge you all to look at the evidence before you and the woman whose life is at stake and to make the right decision. Don't let a wrongful conviction happen here today. The prosecution brought forth 3 witnesses. They called to the stand Detective Jordan Markowitz. Detective Markowitz, an expert in cell phone data analysis, admitted that there is no way of knowing who was in possession of Avery's cell phone on March 6, 2020. Nor can Detective Markowitz confirm the authenticity of Exhibit 14, the screenshots. Detective Markowitz also told you of the several calls and texts made to Avery's cell phone by Taylor Perkins. The phone calls were so short that they could only mean the calls were not answered, and that neither the calls or the texts were returned. This proves that Taylor was calling Avery's phone in an attempt to locate it, and Avery wasn't in possession of her phone on March 6th. Detective Markowitz also confirmed that Blair Rollins' house is across from Avery's, and Blair would take the exact same route to Brackman's house as stated by Markowitz. You also heard from Kyle Cusack, a crime scene reconstruction investigator with a concerning lack of knowledge on her procedure, who was unable to confirm for a fact that the murderer was Avery. Cusack was only able to offer to the court that someone with the same general build as Avery killed Coach Brackman, and considering how many people share the same build, it is impossible to find Avery Becker is guilty. Just think, at Colorado High School alone, there is another student with a near identical build as Avery, that person being Blair Rollins. They also brought forth Alex Fuentes, a senior who's also on the mock trial team with Avery and Taylor. Alex failed to provide her phone for the investigation, considering the modern era and the many ways images can be manipulated. We are forced to reconsider the accuracy of Exhibit 14, the screenshots. Alex also testified that people were trying to say that she gave Avery's phone to Blair. I don't know about you, but I found it very interesting that Alex was defending a theory that was yet to be mentioned when she took the stand. Alex also has admitted to not liking the defendant Avery. This kind of bias could easily be influencing Alex to lie about Avery, and the accuracy of their statement should be taken with a grain of salt. Next, 3 witnesses were put on the stand. First, we brought Professor Blake Van Owen, who showed the initial analysis done by Kyle Kuzak and Detective Markowitz was deeply flawed. Numerous mistakes were uncovered by Professor Van Owen that the police made. And Van Owen showed you that the investigation failed to consider other suspects and even brought forth a more likely suspect, Blair Rollins. Next, we brought up Taylor Perkins. Taylor, who was with Avery the whole day, who's brought to the court that Avery and Blair had a similar body type. And finally, you heard from Avery herself. Avery, who waived her Fifth Amendment right because she wanted you all to know what happened. As the prosecution said, only Avery knows if she was there or not. And as you heard from herself, she was not there. We are all here to let justice prevail. And the way to do that is to confirm what we all know, and that is the fact that Avery Becker is innocent. Prosecution wants you to believe that Avery was spinning a yarn. Meanwhile, they wove together a whole tapestry of lies. Avery wasn't there. She and Taylor were looking everywhere. Thank you, Your Honor.
All right, I believe that brings our trial to conclusion and leaves the jury with its deliberative role.
Your Honor, would you mind if I presented rebuttal?
I don't know that you have any more time. Do you have time, timekeepers?
You
have 30 seconds.
30 seconds? Okay, then the court will allow you the 30 seconds.
Thank you, Your Honor. Your Honor, members of the jury, in Avery's statement, she told her mom she would get back at Brackman if it was the last thing she did. Boy, did she get back at him. When considering all the evidence, the prosecution proved that Avery Becker is guilty of second-degree burglary and felony murder beyond a reasonable doubt. Thank you.
Okay, and that does bring our trial to a conclusion. So members of the jury panel, I guess we can all turn on cameras now, and while you fill out your forms. Is that how this happens? I need some help from.
Sure, you can do that.
I need some help here.
Yes, we'll wait for the panelists to score, then they'll notify me when they get those score sheets, and then you guys can talk amongst yourselves, and then we can dismiss.
Okay, so we'll just wait in great silence, contemplating the scoring.
Thank you. All right, we have all the score sheets received. So if they want to address the council, they can.
So have they all been submitted?
Yes, ma'am. They've been received.
Okay, so then we can chat for a few minutes, can
Sure.
we?
Yes.
How do we, so suddenly my screen went to everybody's small. Is everybody's camera on? I have the Colorado State Bar tournament across my whole screen. I guess I'll look for it. Let me see. So it will, if it's all right to have a little critique. I know you guys are spinning your heads. It's a long time ago that I remember mock trial from being a participant, and then many years later. So let me say this about both teams. What I found was this, first of all, this is a challenge for law students. What they gave you is so hard, and you did a great job with it. This is, when I saw what this case was about, I said, oh my God, they want high school students to deal with this? So you guys did an excellent, excellent job, far beyond your years. Now, let me say that both teams, what I found equally the strong point of both teams was cross-examination. You kept those questions tight and you listened to the witnesses. And that is really, a major, major accomplishment. And the only other thing I will say is for your future, when you get to law school, you want to really learn evidence, because that, winning a case is in part in a trial control. This is your courtroom and you want it to go the way you want it to go. And the way to have the words that come out of everybody's mouth is your knowing evidence and stopping where it might hurt. So with that in mind, and I just wanted to tell the defense why I was tough on the Blair Rollins admissibility. In criminal trial defense, you have here in a case like this, 3 defenses that are pretty classic. You have the alibi, you have the lousy police work, and you have what we used to call the public defenders, the SODD defense, SODDY. Some other dude did it. Okay, and judges, I found, are reluctant to really let you assassinate the character of another person. They'll let you imply that some other person did it, but naming names, judges are really tough about that. So with that in mind, let me call, so we have on the screen Judge Judd, is it on my screen? Is that who I see? Judith, but I can't see names.
Yes, okay, sorry. I'm Judith Judd.
Yes.
And I think they did a wonderful job too. And they were lucky to have you as a judge. I thought you did a wonderful job too, although we're not scoring you. But a few points I hope that will be helpful. Let's, with the openings, I thought both openings gave us a good view of where we were going. And I liked them both very much. But Mr. Briggs, in his opening, he snagged my attention when he said, I urge you to listen. And he also bore down hard on the word truth. And this goes to my point that there are millions of words laid out here in this short period of time. And what gets to you? Think about phrases that cut through and can attach to the person's brain. So that really got my interest. I also would like to compliment Katie Dolan on when she was crossing the defendant's first witness. And the witness said, no, I didn't collect any evidence. And she started to ask another question and she said, no further questions. And I thought that was great time to stop there. And then I'm just a few points. It doesn't mean that all of you weren't really outstanding in many ways. Jessica Batillos was under a lot of pressure from you, Judge. And I thought she stood up to the pressure pretty well and didn't lose her composure. But when she did that redirect on the Taylor Perkins witness, she nailed it. I thought she saved the day with her witness on that. And then Mr. Briggs also did a redirect, which I thought was very effective. But I'd like to say something overall about, because I've seen this happen so many times. Attorneys trying a case are so tied to their scripts that they don't always listen to the answer, or they don't hear what's going on. You think that the question, your brain just thinks, I've got to ask all these questions, and the question is the most important thing. But then sometimes you don't listen. And I thought we had such an example of that early on with the confusion about the admitting the exhibits. And the defense asked that all the exhibits be admitted. And there was no objection, and the judge admitted those. And then you guys were offering the exhibits for admission. And our kind judge just finally went along with that. But you weren't picking up on this situation. And that just goes to the importance of listening and being able to respond to what's going on in front of you, because things aren't script, they don't go according to script, and you get thrown a different situation and then the need to adjust to that. So we kept, admitting exhibits that were already admitted, kind of thing. But it's just an overall comment, but I've seen it happen so many times. And I'm sure you have too, Judge. So I just think about that going forward. And the judge picked up on this because you were the best when you were not on your script, when you were responding to the real situation in the court. But I think you're all fabulous and way above your high school level. Thank you.
Thank you. So who else is a panelist there?
Me.
Please tell me your name. I can't see names.
My name is Susan Latch.
Hi, Ms. Latch.
I echo, first of all, I have to commend everybody on a job very, very well done. And I really hope that some of you decide to go to law school, because I think you're well on your way in terms of your performances today. I echo everything the judge has said. I echo everything Judith has said. I do have a couple comments. I thought that your objections, and well, sometimes they were a little iffy, but your objections and your arguments in defense of your objections or opposed to your objections were excellent. I mean, you really tried to nail those things down. I liked that both teams seemed to have a little theme running through them. The prosecution being revenge gone wrong, and excuse me, the defense being she wasn't there. I think it's a good thing to have a little catchphrase like that you kind of use over and over. I'm not going to name names, but I do have one criticism, and that, well, I probably have more than that, but one in particular that I found most of you doing, and that deals with witness control. And when you're asking questions on cross, you cannot let your witness run away with, what should be a yes or no answer. You've got to shut them up. I know we've always been taught not to be rude, and it's rude, but you have to stop them. No matter how you go about it, and you tried, some of you tried, but you just cannot let them go on and on and on and on. You just have to say yes or no. Just answer the question, and you get nasty with it. Other than that, I think you did very well. One other thing I will mention, I think some of you didn't object when maybe you should have to testimony, but that's, again, it comes with practice. I've been doing this for a lot of years, and I am retired now, thank you God. But you just have to keep doing it. And again, I hope some of you go to law school because you're that good.
Thank you. And we have a third judge panelist.
Yes, that's me. Hi guys, my name is Tiffany and I competed in mock trial in high school and now I compete in college for the University of Michigan. So trust me when I say firsthand, I know the hard work that you guys put into this. It takes a lot of time and it really shows. You guys did great. I'll actually drop my email in the chat if you guys want to message me, feel free to. I guess I will also start with your, what is it? Oh, I didn't know someone said something. I'll start with the open as well. So, like our presiding judge said, this is a really difficult case for you guys to argue. And one bit of legalese I'll harp on, just in case you guys go into the next round or you argue a murder case again, is for the P open, don't focus on there not being intent because that changes the charge. Murder without intent is not technically murder, it's manslaughter. So if you get a judge or a scoring panelist who's very in touch with that, they'll know. And of course, I'm not going to mark you down for that because that's ridiculous, but just keeping in with that. Another thing I wanted to say was your witnesses were all very good, but something to keep in mind going forward is that witnesses can be very down to earth and personable. In fact, as you can continue on with your career, you'll see that they typically score better. And someone I thought did a great job of that, I'm actually going to call them out. The third witness on the P side, Alex Fuentes, you were very likable, you were very down to earth and very personable. And I enjoyed that. And I think people could take notes from that. Although none of you struggled with that hugely, you were good. As far as cross-examination goes, right, wrangling the witness can be a bit hard, but also make sure not to ask them questions that they're not tied to because they can extrapolate and they will. Especially, for example, I know there were questions like that in everyone's, but I'll call this one out. Like asking them, Avery at the end, if they stabbed him. I know we see on TV all the time the movie trials where they're questioning the defendant and they confess. They're like, yeah, I guess you got me, I did it. That's just not going to happen here. And I know your coaches have probably said this because I asked the same questions, trust me. And my coach told me time and time again, you've got to cut that. It's never going to work out for you. And I just advise you to make sure to only ask questions that you can tie them to. But as far as questions like that go, I thought the witnesses did a good job at times of being like, no, disagreeing with stuff like spinning a web is a way of lying. She was like, no, even though rationally we would think like, yeah, she was like, that's not my AF. I don't have to be tied to that. And that's exactly right. You can go on with that. I'm not sure I have too many other comments. If you have any questions, you can feel free to email me. If you're looking to continue doing mock trial in college, you can email me to see what it's like, and I'd be happy to provide any information.
I've given you my email address as well. So if any of you would like to get in touch with me, please feel free to do so.
I will be glad to put that in the chat as well for me. And where do we go from here? Are we all excused? Do we need a supreme judge?
No, you can be excused. I just wanted to give everybody a chance to speak.
Before we kind of leave, I just wanted to, on behalf of both teams, really thank the presiding judge and the scoring panelists and everybody that's kind of putting the tournament together, because we couldn't do any of this without you volunteers. And it's just, we really, really appreciate all your time and effort and taking your time to do this with us, because we appreciate being able to have a season this year. So thank you all.
Yeah,
you're very welcome.
I'd like to ask, I don't know if it's proper to ask what regions you're from. Are we allowed to know that now? Is there any reason why we can't know that? Does anybody? Because I won't. Yeah.
I don't see any reason why not. It seems like the scores are in.
Right.
We're from Colorado Springs.
Okay, welcome to the north. Okay, and prosecution team?
We're from Denver.
Welcome to the north. To the snow. Okay. All right. Take care and the best of luck to you. The best of luck to you. Don't stop. Don't stop, please. Okay.
The snow has started, by the way.
The snow.
At least in my house it has.
Okay. Good luck, everybody. Take care.
Thank you.
Good luck. I hope you move on.
Bye.